It's Tuesday. It's time for coffee and cursey words. I have my coffee and cursey words shirt on. I have not a lot of coffee, a whole lot of cursey words. I have missed you. I am so excited to be streaming today. I am so excited to see all of you in the chat. For all of you that are new, go ahead and put a 1 if this is your first live stream. And for everybody else, welcome back. Welcome, welcome, welcome. Happy August. We have a lot to cover today. Replay crew, love you. To the 3 people that are going to watch this video and be like, your intro's too long. It's time stamped down below. Go look at the timestamps. They're there for you to get to the topics you want to see. I don't think it's too long, and the law nerds don't think it's too long, but if you do, it's down there. All right. Love, love, love you. Replay crew. All the timestamps are down below. We've been running a poll to see what topic we're going to get into first and last. And I haven't told anyone which is which. So they've just been doing the poll. So good to see you. It is time. It is time. It is time to get back to streaming. Welcome. I'm Emily D. Baker. Let's just get into it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. I am so glad to see all your comments and where you're watching from here in Middle Tennessee. The kids are back in school. I'm back to getting up really early to get the kids to school. We're back to that car line life. Like, what? What is car line life some days? But it's a good time for my oldest and I really to just listen to music because we like the same music now because he's that age. And it's a lot of fun, which I think is really good. So little kitty cat said, fun fact I never expected. I think it's easier to learn Mandarin than Korean, but everyone told me it would be the opposite. That is a fun fact. Congratulations on learning Mandarin. Appreciate it. These are deeply pink lights because I feel like a lot of what's going on in the Britney case feels like fuckery to me, but like the legal motions aren't fuckery, like the surrounding stuff is fuckery. So when it comes to red lights, it's like, are we there? Are we not? I'll let you tell me. There is so much. Let's talk about what's on the docket today, and then we will end this poll and see what's going on. So today we have a bunch of updates in the Jen Shah case. We have a bunch of updates in the Britney Spears case. And then I'm going to do a quick update on the Triller H3 case because a lot of you have asked and are interested, and we can do that pretty quickly. And then we have Tati updates in the Swanson lawsuit because, oh my goodness gracious, there's a lot of information in this motion for temporary restraining order against Clark Swanson. The tea is piping hot, even though my coffee is cold, and we are going to talk about it. So yay, that's what's today. So let me see. Wait, what? Lori Hart is saying that Andrew Cuomo has resigned. Well, I guess we're not going to be covering that today. We'll cover that another day. But after all of the news that's come out, I'm not surprised at all. Kayla, any update on Scarlett Johansson? That is going to be an Emily Show podcast episode that I am going to be recording later today. So yes, there will be information coming out about that from me and ScarJo suing Disney. I'm also going to cover Bam Margera suing Johnny Knoxville and MTV in that same podcast episode. So there's going to be podcast episodes coming. So let's talk about all the things. Let's talk about all the things. We are going to, Angel has asked me about Chris Chan. I'm not going there yet. I will, if I do, I will let you know. I am not going to do that yet. Taylor, anything about the charges against Mary Crosby? I need more information because those charges against Mary Crosby, Real Housewife of Salt Lake City. There are some criminal charges, but there are a lot of ways that those can be interpreted. So until I have more information, I would just be speculating wildly. So we will see. The lead attorney's like, let's hear about Britney. I mean, let's see what the poll said. The poll said, Britney Spears updates 59%, Tati gets a restraining order 23%, then Jen Shah, then Triller and Teddy Fresh. So that is the order that we're going in today. I will update that in the docket down below and in the timestamps. We'll get into Britney's documents first. So we're going to kind of work backwards on that because there's a lot there, and the court ruled yesterday in denying one of these motions. But we have a lot of motions to get into. So I will keep an eye on what's going on with Cuomo, and we can address it at the end of the stream. I'm not surprised with the investigations that have come out. So I'm not surprised. And I imagine that news is breaking first on, everyone's favorite news source, Twitter. Twitter is where things happen very, very quickly. So, yay, Starbucks. Let's roll. So chat, I will be back to getting to the super chats soon. I am going to do the Britney stuff first. I am not backing all the way up because we have gone through this case so many times. So I'm going to do a very, very brief road so far. When it comes to the Britney Spears conservatorship, Britney finally has a new attorney, Matthew Rosengart, and he has wasted no time in putting everyone's feet to the fire. He filed on July 26th a petition to remove James Spears as the conservator of the estate. This has been brought before, but not in this way. Remember, Britney's previous attorney, Sam Ingham, who has since resigned, her court-appointed attorney for 13 years, has brought motions to remove James Spears as conservator of the estate. The court denied that motion way back in November 2020, saying that they were going to bring in the co-conservator of the estate. It was going to be an equal co-conservator. That would be Bessemer Trust. After Britney's testimony on June 23rd, Bessemer Trust bounced right out. We want no part of this conservatorship, and they yeeted themselves out of this, and the court allowed them to resign. At that time, James Spears, Britney's father, or estranged father, I think is safe to say at this point, had really fought to not give Bessemer full and equal access as a co-conservator, which raised my little lawyer spidey sense. I was like, he's fighting awful hard to not have them take a look at this, which is why I thought Bessemer Trust coming in to look at it was a great idea. Britney's new attorney is asking that James be removed and that a new conservator be appointed. The individual that they have sought to appoint, his resume was listed in multiple documents, and I have those in the video where I break that down. I will list that down below. It's also on the Britney Spears playlist up on this channel with all of the breakdowns. But he is a CPA. He has experience in forensic accounting. He is a professional fiduciary, meaning he is well-versed in the laws and the responsibilities of a professional fiduciary. Side note, you can't just do what the fuck ever as a professional fiduciary. That's not it. There are rules and obligations and legal obligations to not diminish the estate, to do the right thing, to do what's best for the estate and not yourself. And that has been the heart of Rosengart's motions with regard to getting rid of James Spears, saying, look, it's in the best interest of Britney to get rid of James Spears. And Jody Montgomery has joined in that petition and has issued her own signed declaration in that. So the first document that we have not covered yet is Jody Montgomery's joinder to this motion. So there's Jody Montgomery's joinder, which means I'm literally joining you. Joining of the motion, like the joining. We are joining. We are joining in the motion. We are here. We agree. Do the things. So Jody Montgomery's joinder. Then we're going to get to the ex parte application to advance the hearing from the end of September to August, which was denied by the court. We're going to get to James Spears's opposition to that because there is definitely some new information in that. So let's start with Jody Montgomery's joinder because we have not covered that yet. We're going to go over this pretty quickly because the declaration has slightly more information than we've already covered, but not a ton. So this will be a quick scoop over this motion because, again, there's a lot to cover. There's a lot. Britney's going to get a dedicated stream again soon, I am sure, because we're just going to need to. Let me pull this up as big as possible. One, so y'all can see it, and two, so I can see it, because let's be honest, we're getting new glasses. I'm very excited so we can read the screen better. Hopefully y'all can see it well. Let's get into this. This was filed on July 28th. This is the verified joinder. This is Jody Montgomery as conservator of the person, temporary conservator of the person, because James Spears has not given up that power yet. Remember, he has not allowed Jody Montgomery to take over as the full conservator of the person because he has not relinquished that power. It's right. So she is the temporary conservator of the person, and that has not been addressed. So she is joining in the motion to yeet James Spears. She has concluded, Ms. Montgomery, that James Spears should not continue to act as the conservatee's conservator of the estate. Say that 10 times fast. The conservatee's conservator of the estate, because his doing so is not in the best interest of the conservatee. I mean, this has been the case for a while. It just, none of the attorneys have approached it this way so far. And I think Jody Montgomery was trying not to rock the boat, because at the end of the day, the things that she asks for Britney as the conservator of the person have to be approved by the conservator of the state who holds the money. So the person who holds the purse strings is the person you're trying not to piss off, right? So I think she has kind of bit her tongue in this, because if she's asking for things for Britney and he's denying them, she has to have a good working relationship with him for that reason. But now that Britney's attorney's coming in, like both guns blazing, she's like, I agree. Here we are. We agree. It's already happened. The shit's already out of the horse. So we might as well just go ahead and join with this motion. So she is saying that she seeks the same relief as prayed for by Ms. Spears in the petition for removal. She joins in the nomination of Jason Rubin, the CPA. She supports the removal petition and adds more information in her declaration. She states that Britney's medical team agrees that it's not in the best interest of Britney for Dad Spears to remain the conservator of the estate. She says that Britney has told her, Ms. Montgomery, that it's her wish for Dad Spears to be removed as conservator of the state. Look, she's told everybody. Who the fuck hasn't she told? She's told the court at least twice recently, in June and in July. But she told the court 2 years ago. Her attorney has made motions as early as, mid 2020 to remove him. This is not new information. They have been trying to remove this man for well over a year at this point. So this is not news to anybody. Maybe it's news to the court. Perhaps. It can't be. She's already denied the motion. All right. So the declaration is not attached to this one. The declaration was attached to the original motion that we've already covered. So let's get into the next one. This is the next motion from there this was on August 5th. No, this was on July 28th. On August 5th, Sam Rosengart makes an ex parte petition to advance the court date, meaning let's speed this up. There's no reason to wait. Why are we waiting till the end of September? This is dumb. Let's just do it now. So let's get into that petition real quick before we get into the objection to it. This is the non-appearance ex parte. That means one party only without the other party. Application for an order advancing the 29th hearing on the petition to remove James Spears. So this is not asking to remove Dad Spears. This is asking to take the hearing from September 29th and move it up to a sooner date. That's what it's asking for. They're asking for the immediate suspension of James Spears. In the alternative, we know that that's been denied. So we're going to look at the reasons, but we're not going to really hammer on it too much because, again, we know that it's already been denied. So on Friday, August 6th at 10 a.m. or soon thereafter, the conservatee Britney asked the court on an ex parte basis, that means just Britney and her side, we don't need the other side, to move up the petition from the September 29th date. They include the points of authorities and the testimony from June 23rd and July 14th, petitions and supporting declarations of Jody Montgomery and Lynn Spears filed on July 26, 2021. We've gone through those. A new declaration from Rosengart and the verified joinder from Jody Montgomery filed on July 27th, which we just went over, where Jody Montgomery says, yes, yeet him. It's a good idea. It's a good idea to remove his ass, get him out. We agree. This application seeks uncontroversial relief. Well, it's controversial to somebody. Dad Spears. He is fighting like hell to stay in this conservatorship. And well, we'll get to his objection. We'll get there. I'm getting ahead of myself. I'm getting all angry already. It's too early in the stream for me to be angry. We're like 15 minutes in and I'm like, oh, fuck this shit. But here we go. Uncontroversial relief, which is in the best interest of Miss Spears. Does anyone disagree with that statement? Who disagrees? James Spears, you better not be raising your hand in the chat. You're yeet thyself. Who disagrees with that? No one. Two people on Twitter and James Spears and his legal team. Uncontroversial relief, which is in the best interest of Miss Spears and should be supported by the conservator of the estate, James P. Spears. I love the way that Rosengart has written these motions. He has really painted Dad Spears back into a corner saying, look, your job as conservator of the estate is to do what's in the best interest of the estate and the conservatee. What's in their best interest is not you. So if your job is to act in their best interest and their best interest is not you, then it's your job to remove thyself and allow this to move forward with a professional conservator, not you. So they're asking for an order advancing the hearing date on the petition to remove James Spears, presently set for September 29th, to the earliest date this court's calendar will permit, or on or after August 23rd. I think I said on social August 13th. You know why? Because this says 23rd, and August 13th is the date that the Tati Westbrook TRO got moved to, and I conflated the two. Not surprising. Not surprising that I conflated the two dates. Either way, it's not going to happen on the 23rd because the court said no. There can be no actual prejudice to Mr. Spears because these petitions will be heard in 15 days, meaning he has enough time to respond. But Rosengart has pointed out, why would he respond? Why would he waste Britney's money? Why would he waste the legal fees to argue against what she wants? His job is to do what's in her best interest and in the best interest of her estate. Why would he argue? Everyone agrees that this is in her best interest. So he shouldn't fight, so we can just hear it in 15 days. Why is this hard? This shouldn't be hard. And then it's hard. And now it's hard, apparently. Furthermore, all interested parties forcefully agree that Mr. Spears' continued presence as conservator of the estate is contrary to Britney's best interest, health, and well-being, and that his prompt removal, or at the very least his immediate suspension, is critical at this juncture. See the July 22nd, 2021 declaration of Jody Montgomery that we covered in the last video addressing this. Again, medical team agrees. I agree. Everyone agrees it's in Britney's best interest and in the best interest of her mental health and well-being. In short, for a very legitimate, compelling reason, in the conservatives' best interest, the time has come for Mr. Spears' reign to end. Winter is coming, James Spears. Matthew Rosengart is apparently the Night King in this. Wait, no, is he the Night King? Is he Jon Snow? You let me know in the chat. Who is Rosengart in this very awkward, very strange Game of Thrones analogy? Is Britney Daenerys? Is she Mother of Dragons? You let me know. If we're casting the Britney Spears case as Game of Thrones, who are the characters? Chat, I trust you to do this better than I would. Back to this motion. It says this application, however, simply asks that the pending hearing is advanced to the earliest date under the code that this court's calendar will permit, so that one, if Dad Spears chooses, listen, watch him paint Dad Spears back into the corner. Watch this happen. If Mr. Spears chooses to put his daughter's well-being first and accept an outcome that does not even ask him to admit fault, Miss Spears can begin to have some semblance of her, quote, life back. or 2, if Mr. Spears chooses to put his own self-interest first by opposing his ultimate removal, thereby putting himself at risk for attorney's fees. We'll talk about that in a minute. This court can take that fact into account in determining whether to suspend Mr. Spears pending the outcome of that litigation. Indeed, there already is substantial recorded evidence warranting Mr. Spears' suspension now. And should he seek to promote delay by opposing this application, any such opposition would speak volumes. Corner, meet James Spears. If you are doing your job as conservator of the estate, you're going to do what's in the best interest of Britney. Britney's best interest is to remove you. So you will do the right thing and bow out. If you choose to act in your own self-interest, then it proves that you shouldn't be the conservator of the state because you're acting in your own self-interest and not Britney's best interest. There's no other option. They've left no other option. It's either you do what's best for your daughter or you do what's best for you, and either motion speaks volumes. And, James Spears woke up and chose violence, not in the literal sense, in the hyperbolic sense. In the context, I don't expect the boomer lawyers to get it. In the context. Let's get back to this motion. Good cause exists for granting this application on June 23rd and July 14th. Spears poignantly described the often nightmarish circumstances of her 13-year conservatorship, which has been dominated from its inception by her father, James P. Spears. Among other things, Miss Spears describes the trauma and abuse she endured under control of her father and those beholden to him, several of whom are being enriched from monies earned by Spears without her actual consent. Spears also explained that she has been traumatized, felt like, quote, I was dead, and like, quote, I didn't matter. See, that is a gentle poke at the court, because when Britney said those things, she was talking about Judge Penny not listening to her in 2019. She was saying, look, I came before this court already and you didn't hear me. It made me feel like I was dead and like I didn't matter. So Rosengart is gently pointing out, remember, Your Honor, this is how she said it made her feel when she pled to this court for help and nothing happened. Less than 2 weeks after this firm's July 14th initial appearance, and as a first step, Ms. Spears petitioned this court for her father's removal, nominating a highly regarded licensed fiduciary as successor. Mind you, they also picked someone who was familiar with this judge and this court, who worked in conservatorships in this court. So it's not like the court can be like, ooh, we don't know who this person is. You do. They picked someone who was well known to the court, who works within this system, and that should make it an easier transition. The July 26th petition did not require Mr. Spears admit or require that the court find that Spears acted wrongly, even though there's ample cause to believe that he has. Instead, petition invoked and is based solely on a specific provision of the probate code, section 2650J, which vests this court with broad discretion to order removal if it is in the best interest of the conservatee. This is, again, really well done by Rosengart, saying, look, Your Honor, it's not that deep. It's not that deep. You don't have to say he did anything wrong. We think that he did. You don't have to say that he's a piece of shit. We think that he is. You don't have to make any finding other than it's in Britney's best interest that he be removed. That's the only finding. We have made it so easy. All we're asking is for the court to say it's in Britney's best interest that her dad gets yeeted. That is it. And you have the conservator of the person, the mother, and the lawyer saying this is what she's asking for. You have Britney in her own words saying it is best for me to have him removed. I want him removed. She said it twice in the last 2 months. Best interest. It's all you have to find. There is nothing else you have to do. This is simple. It's not dramatic. Why is this hard? This shouldn't be hard. Just yeet. They've made it so easy for the court. I think she could have moved this date ahead. I have big questions as to why she didn't. We'll get there. We'll get to my questions. I have so many questions, y'all. I have so many questions. The petition contains overwhelming evidence warranting Mr. Spears' prompt removal, and we went through that entire petition. Similarly, Lynn Spears has declared, it's clear to me that James P. Spears is incapable of putting my daughter's interest ahead of his own. So we'll get to his objection in just a moment. These are all things that are contained in the last motion that we've gone over. Rosengart then goes on to ask or to argue to the court that in order advancing the hearing date is necessary to protect the best interests of Britney, saying first, as evidenced by her petition, her testimony in open court, Jody Montgomery's declaration, Jody Montgomery's joinder, and Lynn Spears' declaration in support of the removal, Mr. Spears' presence as conservator is causing continued emotional and psychological distress. Best interest. They go on to say, second, Ms. Spears has indicated, as her prior counsel stated, that she will not work until this issue is resolved. And it's been a year. They then say this will cause the estate to suffer additional loss of income. Remember, best interest. James Spears is supposed to do what's best for the estate. If Britney is saying, I won't work while he's there, how do you argue it's best for the estate that he stays? Right? Right. Pointing it out very clearly for the court. The hiatus caused by abuse, trauma, and Spears' fear of her father potentially deprives the estate of millions of dollars annually and further impacts her well-being insofar as she is unable to pursue her career and life's passion without feeling suffocated by her father's oppressive oversight and micromanagement. As Lynn Spears' July 22nd, 2021 declaration provides, the arrangement created by Mr. Spears has been exhausting and terrifying, like living in custody. And that was in the previous petition that we covered. They then go on to argue about the amount of money that James Spears is spending, including that Mr. Spears' litigation counsel, Holland & Knight, H&K, Hell's Kitchen, alone seeks compensation from Britney of $1.3 million in attorney's fees from October 2020 to June 2021, including, they say, a shocking and inexplicable $541,000 for media matters. Now we all know that's less than that's apparently less than Trisha Paytas makes a month, but if facts, it's a lot for Britney to be paying for media matters for her daddy's attorney. Spears has also enriched himself at the expense of his daughter, reaping millions of dollars from her services as a performer, in addition to paying himself $16,000 per month from her estate, $2,000 more that he has allotted to her, and $2,000 a month for office expenses. Now, we will go over on Friday. Some of the historic documents have just recently become available that include Dad Spears. One of the first things he did in 2008, hold on to your shocked Pikachu gifts, friends. Hold on to the gifts. One of the first things James Spears did at the beginning of this conservatorship was to pay himself. Yes, it was to lease a car, to pay himself. Britney wasn't allowed to drive, but James Spears needed to lease a car. I have questions. We're going to get into that on Friday during Friday Night Live, during some of the historic documents. But these were more pressing because these are happening right now. The motion goes on to say that these spendthrift ways are particularly problematic when contrasted with the stringent, quote, absolutely microscopic control that Dad Spears has exerted over his daughter, evidently since her childhood and continuing through today, per the Lynn Spears declaration. They say further, and by way of illustration only, although a full recitation of facts discovered thus far in just 2 weeks is beyond the scope of this application. Warning, warning, this shit's really bad and more is going to come from it because in just 2 weeks we found out a lot of shit and we are going to be bringing that shit up, but we're not there yet. Warning, 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 danger, danger, Will Robinson, danger, James Spears, danger. You are going to be investigated. Before I spiraled there. Further, and again by way of illustration only, although a full recitation of facts discovered thus far in just 2 weeks, 2-3 weeks, is beyond the scope of this application, whether out of misfeasance or something far worse, Mr. Spears appears to have at least grossly overpaid Miss Spears' former business manager, TriStar Sports and Entertainment. Warning, Lou Taylor, warning, warning. We want to know why you got paid so much motherfucking money. Yeah, why? And James, you're supposed to be taking care of the estate, which means you're supposed to be negotiating beneficial deals for the estate. Beneficial deals for the estate, not just signing off on hundreds of thousands of dollars. Matthew Rosengart, former prosecutor, has some questions. I bet his colleagues might too. Anyway, allowing it to extract exorbitant sums of money from the estate without Spears's actual consent. Oh, TriStar, welcome to the party. We want to know why you're getting paid so fucking much too. For example, in December 2019, Spears inexplicably approved a payment to TriStar in excess of $300,000 above. This is in addition to the approximate $200,000 that was supposedly payable to TriStar at the time. This $300,000 payment was not due to any extra duties or work performed by TriStar. Right. Because Britney wasn't working. To the contrary, and for whatever reason, Dad Spears complied with TriStar's request for $500,000 from the estate as a floor. Like, hey, just so we can be here, $500,000. $500,000 just for us to be here for you. More problematic, this payment was sought and paid despite Miss Spears' indefinite early 2019 hiatus. That is, rather than negotiating new, less lucrative agreement as a result of Miss Spears' hiatus or moving Spears' business management elsewhere, Dad Spears allowed TriStar to siphon more than twice of Spears' annual allowance out of her estate while she was on hiatus. When cast even in the most benign light, even if we don't think you're a shady motherfucker, this decision prioritized TriStars over the estates. Let's just talk about the decision making here. That was objected to, by the way, and it went through anyway. So that had come up. Not Lou Taylor. We talked about this motion ages ago, but Sam Ingham was like, wait. You should have at least negotiated this. But what had happened, it was all put in the motions. There was like an email from TriStar like, hey, we think we need this. And James Spears emailed back, yeah, cool. Essentially, I'm summarizing, but his email was super short, same day. Yeah, that sounds fine. Just agreed to it. No negotiations, no conversation, no running it by anyone else. Just like, yeah, cool. Seems fine. In their footnote, they say, TriStar footnote voice. We'll get there. We're not to the footnote yet. I was getting ahead of myself. Let's get to it. A conservatorship should be a last resort designed to benefit the conservatee rather than a mechanism designed to serve as a tool for enrichment of third parties. Now we get to footnote number 3. TriStar and its principal Lou Taylor have been accused by third parties of attempting to utilize conservatorships to their business advantage. See Ronan Farrow and Gia Tolento, Britney Spears' conservatorship nightmare, The New Yorker, July 3rd. So the New Yorker article has come back up. Although these allegations have been denied by TriStar and further investigation is warranted before conclusions are reached, the exploitation of Miss Spears and the presumption that Britney Spears' brand is what needs protection is more than troubling. It also flies in the face of the legislative and judicial intent of the probate code to serve the conservatee's best interest. Now, it's not Friday night, but a lot of you are international. It might not be night where you are. I would not suggest taking a shot every time we talk about the conservatee's best interest, because apparently in the course of this conservatorship, that principle has been completely fucking lost. And it's being pointed out again, the protection of the Britney Spears brand might not be what's in the best interest of, Britney Spears. Maybe we protect her first and worry about the brand later. Oh, but maybe that's hard if you're James Spears and you've negotiated deals where you get a kickback of all the work that she's doing. Maybe that, perhaps. They go on to talk about the estate exploiting Miss Spears for their own benefit, talking about the court. If the court cannot grant this application due to calendar constraints, again, giving the court an out. I understand that Your Honor is busy. I understand that August is the time for vacation. But if you can't grant us the expedited hearing, I get it. You should suspend his powers before further delay in his removal. The court didn't do that either. They say for the same reasons outlined above, we submit that the ongoing loss and injury to Ms. Spears and her estate are more than sufficient for the court to order his suspension now, regardless of when the hearing on removal occurs. Conclusion, given the ongoing harm that each day Mr. Spears remains in place, it's in the best interest of Ms. Spears to remove him. Yeah, it is. Declaration of Matthew Rosengart. Unless expressly Otherwise stated, I have personal knowledge. On August 5th, prior to 10 a.m., my office will have transmitted by email to counsel of record notice of the date, time, and place of the application. The notice will have gone to, and it talks about notice being given. July 26th, my office filed the petition for removal and all documents. The petitions were set mid-December. That was advanced to September 29th. It talks about the Jody Montgomery petitions, the testimony of Miss Spears, the fact that rather than promptly approving his 39-year-old daughter's right, vacation, hold on. The testimony of Miss Spears and the above reference evidence speak for themselves. By way of one additional brief illustration concerning Mr. Spears, Britney wanted to take a short vacation to Maui in late July. Given Dad Spears' present position, his consent was sought by Spears' team. Rather than promptly approving his 39-year-old daughter's right to take a well-earned vacation supported by her own hard-earned money, Dad Spears or his representative opposed the trip as unnecessary. Give the girl a fucking vacation. Why can't she go on vacation? Maui's always a good idea. It has been a rough few months. Let her go. We all need a vacation. Maui's always a good idea. Maui's always necessary. Always. For all of us. I mean, except for maybe me. I love a Disney cruise. I'm just going to say. But vacation's always necessary. Unnecessary. Even as Dad Spears was paying himself from her estate, although this firm ultimately obtained approval for the trip. Oh, I would have loved to have been a fly on the wall for that conversation. Can you imagine? I can't imagine. I'm a former prosecutor. I know what I'm like when I'm angry. I can absolutely imagine a phone call between lawyers where you're going, you know how bad this looks for your client? What in the ever-loving fuck, respectfully, are you thinking? And if you want to hear the way that sassy lawyer letters go, Nick Rekieta has a video on his channel talking about a lawyer sending him a cease and desist and his response to it. So if you want to see what a mild lawyer sass looks like, because it's good lawyer snarky sass, if you want to see lawyer sass, he's got a great video on his response to it that ends with, and also fuck you. I imagine that's how this conversation went with Rosengart and whoever he talked about. Respectfully, what in the fuck are you thinking? With all due respect, this looks terrible for your client who just seems to be greedy and just seems to be enriching himself and doesn't really give a fuck about his daughter, though he keeps putting in court documents, her daddy loves her so much. Well, if daddy loves her, let her go to fucking Maui, because your actions are definitely speaking louder than your attorney's words right now. I would have loved to have been a fly on the wall for that conversation. So yes, approval for the trip was obtained. This dispute caused understandable anguish to Miss Spears, a functioning adult who has earned tens of millions of dollars in only the past few years and has substantial future earning power as well, should she choose to exercise that power. Although Miss Spears' health and well-being are paramount, there are financial and other considerations that are relevant. As reported to the court by her previous attorney, Miss Spears will not return to work until while her father is serving as conservator. And then this reiterates what else is in the petition. How do we feel about Dad Spears denying Britney's vacation? I mean, FFS at this point. Let's see what he says about denying or refusing to yeet himself out of this conservatorship, because that's what's happening next. Let's pull up Dad Spears's opposition to the ex parte application for an order advancing the date. Note, he did not directly oppose yet to the order to remove him. This is an opposition to advancing the date. I have not gone over this yet. This is a live reacts. I've gone over all the other documents that we're talking about today. This one, I have not taken a moment to go over because I wanted to do it live with y'all, because I had some previews from people discussing it on social media. This was filed on August 6th. What's today? August 10th. So this was just a few days ago. All right. Let's get into it. James Spears' opposition to non-appearance ex parte application for an order advancing the September 29th hearing date on the petition to remove James Spears as conservator of the estate or for his immediate suspension. Declaration of James P. Spears. Oh my God, it's exhausting. James P. Spears, conservator of the estate of Britney Spears, respectfully submits his... Did you hear my mouth didn't even want to say respectful in connection. It was hard. Respectfully submits his opposition to the non-appearance. We said all of that twice. On August 5th, Matthew Rosengart, counsel for Britney Spears, served 2 identical ex parte applications with the same title seeking the same relief. But Mr. Spears assumes that only one was filed. I mean, right, probably. You got 2 of them. Not a big... Why point it out? Why point it out? Why point it out? Shade. Lawyer shade. Again. Allegations and shade. These are all petitions. These are sworn declarations where people are saying things are true, but this is what they're saying. You are free to come to your own conclusion. I think we know how I feel about it. I feel like Rosengart makes an excellent point. The point is that this is in Britney's best interest. Dad Spears is clearly not in her best interest. So why? Why all the fighting over this? Mr. Spears does not oppose the request to advance the September 29th hearing date. Then why? Then why was it denied by the court? Judge Penny on vacation? In a little vacay boo-boo? On July 26th, Ms. Spears' new counsel, Rosengart, filed 1, Conservatives' verified petition for suspension and removal of James P. Spears, 2, petition for appointment of successor probate conservator. Although the petitions were initially set for hearing on December 13th, at a hearing in this matter on July 14th, the court approved an earlier date so the hearings could be heard on September 29th. Rosengart was present in court on July 14th, but made no request for an earlier date. Footnote 2. The other date offered by the court as an alternative is one in which Mr. Spears' counsel stated they have a conflict because, among other reasons, it is a Jewish holiday. Okay, I don't know why that's necessary. That would be in the court record, but fine. Almost 2 weeks later, Rosengart filed the instant ex parte application to advance the petitions to the earliest court date. The ex parte application relies on the same declarations that were filed. The ex parte application relies on the same declarations that were filed in support of the petitions, adding only that Rosengart's own declaration, which is comprised of unsubstantiated, vague accusations and a false statement about Mr. Spears opposing a trip to Hawaii. Who do we believe in this one? Who do y'all believe? Do y'all believe Rosengart's statement that Dad Spears objected to the Hawaii vacation? Or this is probably submitted by Vivian Thoreen. Let's just go to the bottom and see who this is submitted by. There it is. Vivian Thoreen says, that's not true. That's not true. He did not oppose her vacation to Hawaii. I would love more information about that. Indeed, Rosengart's declaration does not and cannot specify what the wrongdoing is or the particular actors who have allegedly committed this wrongdoing. Well, probably because he doesn't know who denied the funds. Accordingly, Mr. Spears affirmatively objects to all of the declarations cited and filed in support of the application. Further, there is absolutely no urgency justifying the ex parte relief. Well, you said you're not opposing it, but then you're opposing it. No. That's not how that works. Don't say we're not opposing it, but also let us oppose it. No. They're saying there's no urgency. Application must make an affirmative factual showing in a declaration containing competent testimony based on personal knowledge of irreparable harm, immediate damage, or any other statutory basis. I offer that any other statutory basis is best interest of Britney, and that irreparable harm comes from the sustained and prolonged treatment of Britney in this matter and her own desire to have him removed after saying it since 2019 and feeling like no one's listening to her, perhaps. If this matter was as urgent as Rosengart claims it is, why wasn't this ex parte application concurrently filed with the petitions on July 26, 2021, or addressed on July 14th? It's a fair point. What has changed since then? Hawaii. They say nothing. But it is a fair point because it was, just a few days between the two when he agreed on July 14th to the date, but it might have become more urgent for Britney saying, I can't wait till the end of September. So something might have changed for her that is also not part of this record. This ex parte application would have been entirely unnecessary if Rosengart had informed the court of his intentions at the hearing on July 14th. His client might have changed, or even if he had conferred with the undersigned on this matter. Your Honor, Mom, he didn't even call and ask us to move the date forward. So if he had done that, we wouldn't have objected. And we're not objecting now, but by way of not objecting, we're also kind of objecting. Okay. Nonetheless, they say there is no urgency justifying the ex parte relief and no requisite showing of good cause has been made. Mr. Spears does not object to advancing the September 29th hearing date to the court's next available date on or after August 23rd. If there is a date that works for the courts, Mr. Spears will not object. Your Honor, we're cooperating. Mr. Spears' counsel is unavailable August 26th, 27th, 30th, and September 7th and 8th. Which is actually a really helpful footnote because don't have the court set it on a date that you're not available. Here's my calendar. Any other date would work. The court denied it anyway. The court need not consider the alternative request for suspension by its own terms. Ex parte application simply asks the pending hearing be advanced. No, it also asks for a suspension. The request for suspension is only made as an alternative request if preliminary relief is opposed or rejected. Mr. Rosengart is not asking for serious suspension if the court's able to advance the date. So the analysis stops here as the court need not address the alternative relief because they're not objecting to the date. No grounds exist for Spears' suspension. Although the court need not address the alternative relief, the legal writing at least is very clear. I don't always agree with what's being argued by Dad Spears' side, but the lawyering, for what it's costing, the lawyering's not terrible. And it's at least clear. I don't agree with everything that's said. I have questions about a lot of it, but at least it's laying it out very clearly, which is always appreciated. We're going to just give credit where credit is due. Although the court need not address the alternative relief, there are no grounds whatsoever to suspend Mr. Spears. When I say I have questions, there are statements like that are very conclusory, and I have questions. Here we go. James Spears loves his daughter. Daddy loves you, Britney. Here we go. And also, what is the world of an adult female lawyer, Vivian Thurin, that has to be in court saying shit like, Mr. Spears would like the court and Britney to know that, Daddy loves her. What in the world? Anyway, I digress. This is not an opinion. For over 13 years, Mr. Spears has dutifully and faithfully served as conservator of his daughter's estate without any blemishes on his record. This is not an opinion. What about the money? He has taken the estate from being in debt and facing tens of millions of dollars in lawsuit to a current value of well over $60 million. Mr. Spears' record speaks for itself. Yes, let's let the record speak for itself. Let's take a look at that record. And if you want to take a look at that record, why did he fight so hard to keep Bessemer from looking at the records? Just a question. He's filed annual accountings for over a decade that have been thoroughly reviewed by Miss Spears' attorney and this court. That's true. And subsequently approved without objections. The 12th accounting is still pending, and there were objections to the amount of money being spent by the attorneys to start with. But that goes to everyone's failing, not the fact, I think not just the fact that he's done a good job. I think it goes more to the fact that everybody maybe did a shit job. Mr. Spears did this while also serving as conservator of the person. Oh, it's so hard. Until 2019, and working hard with a team of professionals to restore the conservative to good health, reunite her with her children, whom she had lost custody of and had no visitation, and help her revive her career. Throughout his service as conservator, Mr. Spears' sole motivation has been his unconditional love for his daughter and a fierce desire. Other words stuck in my throat. Money. For money is what's stuck in my throat. But that's just shade. And a fierce desire to protect her from those trying to take advantage of her. Let y'all make your own decisions on that. The conservatorship continues to exist, and Spears continues to do the job that he was appointed to do. This court considered and denied a similar request to suspend Mr. Spears filed in November 2020, finding no basis to suspend Mr. Spears. Exhibit A, minute order dated November 10th, 2020. Just as before, there's no grounds to suspend Mr. Spears. Rosengart's request is based on 1, Untested testimony provided by Miss Spears. Oh, there it is. Britney, yeah, we don't believe you. It's untested testimony, meaning, Your Honor, this is not sworn, not cross-examined. Can we really believe what Britney was saying about how she was feeling? That's what that says. Untested testimony. 2, allegation and events largely related to health and medical issues for which Jody Montgomery has been responsible since late 2018. And 3, vague, conclusory, and unchallenged declarations submitted by Lynn Spears, Jody Montgomery, and Rosengart himself. Your Honor, all of this is bullshit. So you don't have to listen to them. Remember, you trust us. Keep trusting us. You like us, Your Honor. We're so good. Look, so pretty. So pretty. At a minimum, Rosengart's suspension request raises serious and complicated legal and factual issues that require a full opportunity to be heard and cannot be resolved on a non-appearance ex parte basis. We're going to fight this shit. You better believe it. For example, Rosengart relies heavily on the unsupported hearsay assertions that the medical team believes that Spears must be removed. There's absolutely no explanation of any basis for this, but it seems to be related to the testimony provided by Ms. Spears on June 23rd at a status hearing covering a wide variety of issues involving both the conservator of the person and estate, including but not limited to serious allegations regarding forced medical treatment and therapy, improper medical care, limitations of personal rights, to name a few. The issues regarding Ms. Spears' medical treatment are indeed serious, but Mr. Spears has not been in control of her treatment since late 2018. Highlighted, underlined, bold. It was Jody Montgomery, along with the Conservatives' former attorney Sam Ingham, who admitted Miss Spears to a facility in early 2019, including but not limited to signing the admittance documents, Declaration of James Spears. It was them. It wasn't me. It was them. Everything Britney's complained about was them, not me. Miss Montgomery has continued to have control over Miss Spears' medical treatment and personal life ever since. Based on Spears' statement to the court, it's clear that Spears does not know or remember that Miss Montgomery directed and coordinated the medical treatment she is so angry about, and her former court-appointed counsel's involvement in and approval of the same. First of all, her court-appointed attorney can't approve of anything. Really? I mean, there weren't objections made, if that's what they mean by approval. But those are things that happen between the conservator of the estate and the conservator of the person, meaning the only person who really could have approved to these things are James Spears, because he's the one in charge of the money, which is why Jody Montgomery's attorneys released a statement saying that this objection was all a bunch of BS. Mr. Rosengart also quotes Miss Montgomery's assertion that removing Spears is critical, but neither explains why. Is it not obvious? It's unclear whether this assertion is related to Miss Spears' current psychological state. Oh, now we're going to question her mental well-being. Good. That was sarcasm. Her medical treatment or something else completely. This claim is ironic, however, in light of Miss Montgomery's recent plea for help from Mr. Spears when Miss Montgomery felt that Miss Spears was spiraling out of control. They're going to just throw Britney right under the bus, back it up, and run over Miss Montgomery too. Everything that's been sealed, everything that's been private so far, we're just all of it. Dad Spears is not going down without a fight, but who does the fight benefit? Who does the fight benefit? Does it benefit Britney? Or does it benefit his public perception, public persona, and his reputation? Who does this all benefit? That's the question I want you to ask as you're listening to this next bit. Again, this is all also hearsay. Mr. Spears received a call from Miss Montgomery on July 9th, 2021, in which she sounded very distraught, expressed concern about Miss Spears' recent behavior and her refusal to listen or even see her doctors. She made that clear on June 23rd. Very clear. Miss Montgomery pleaded for Mr. Spears' help to address these issues. Mr. Spears explained to her that he would do anything to help his daughter, except let her go to Hawaii, allegedly, but was limited in this ability since he no longer has access or insight into any of his daughter's medical information. Mr. Rosengart also raises financial issues regarding the amount of attorney's fees that have been incurred by the estate and payments that were made. to the Conservative's former business manager, but these are ongoing matters that have been at issue for some time in the proceeding over the 12th account. They support no claim of urgency sufficient to justify ex parte relief. Well, that's actually fair because those things are still not resolved on that 12th accounting and have been bumped over and over and over because there's been bigger issues. Conclusion: the issues raised in the petition must be addressed by the court and will be addressed in due course. There's no hurry here. Let's see what James Spears has to say in his declaration. I served as conservator of my daughter's person from February 1st, 2008 until September 9th, 2019, when Jody Montgomery was appointed temporary conservator of the person. Although I did not formally step down, no, you sure didn't, as conservator of the person until September 2019. He still hasn't formally stepped down. He has stepped aside, but he still retains those powers. So if Miss Montgomery were to leave, he would be conservator of the person again. He has not formally resigned. I had no control of my daughter's medical treatment since late 2018, when, due to my own health issues, I had to step back in this role. I had to step back. I had to step back, step down, step aside. Instead, on August 21, 2018, I hired Montgomery to serve as my daughter's case manager and assist in all aspects of medical decisions. It was Miss Montgomery in the kitchen with the candlestick. It was Miss Montgomery, along with the Conservative's former attorney, Sam Ingham, who admitted Miss Spears to a facility in early 2019. Well, I guess this shit's all going to come out, and we're going to find out more about it, including but not limited to signing the admittance documents. Miss Montgomery has continued to have control of my daughter's medical treatment and personal life ever since. On July 9th, I received a phone call from Miss Montgomery. During our call, Montgomery sounded distraught and expressed how concerned she was about my daughter's recent behavior and overall mental health. Montgomery explained that my daughter was not timely or properly taking her medication, was not listening to the recommendations of her medical team. Okay, so what is it? If the recommendations of her medical team are to remove James Spears, then why doesn't he just go, okay, well, that's the recommendation of the medical team? Because it seems like that would be him helping listen to the recommendations of the medical team. But he said, well, Britney's not listening to the medical team, and that was so concerning. But now it's like, but are those really the recommendations of the medical team? You can't argue out of both sides of your mouth on this. I refused to see some of her doctors. Miss Montgomery said she was very worried about the direction my daughter was headed in and directly asked for my help to address these issues. I wonder how that was all phrased after the June 23rd hearing. There's a lot of ways to take a phone call, and I wonder if it's like, we need your help. We need her to see these doctors and not those doctors. We need approval for these doctors, not those doctors. She doesn't want to deal with you. I wonder. We also discussed the allegations that my daughter made at the recent status hearing on June 23rd. And the need to address these directly with my daughter. Miss Montgomery acknowledged that many of my daughter's statements at the last hearing were not true and attributed her statements to the fact that my daughter is, quote, mentally sick. What is the purpose of putting that in here? Other than to diminish perception of Brit? No. I can't conceive of another reason. I can't conceive. Is the reason to poke at Jody Montgomery, or is the reason to poke at Britney? Or is the reason to cause the court to question Britney's competency or to question how far Britney has come? But again, even if somebody has mental health struggles, they're still allowed to have autonomy and make decisions. I explained to Miss Montgomery that I would do anything I could to help my daughter, but was limited in this ability since I do not have access or insight to any of my daughter's medical information. No, you just have access to the money. You can just approve things. After Miss Montgomery shared her detailed concerns about my daughter's recent behavior, safety, and overall health, she raised potential options, including a 5150 psychiatric hold, which raised my concerns. The conversation ended shortly thereafter when Montgomery said she would update me on my daughter's condition and would follow up on what I could do to help. On July 13th, I received an email from Miss Montgomery in which she acknowledged our call, but backtracked on most of the details she shared with me and discounted the need for a 5150. All of this is going to come into court in the next hearing, and the judge is going to be like, what in the ever-loving fuck is happening? Why are we fighting like this? And is any of this in the best interest of Britney Spears? But that court hearing is not going to be until at least September 29th, because the court denied the request to advance the hearing. This is the order from the court that was filed yesterday on August 9th, 2021. This morning before I streamed, I checked the court records. There was nothing new. That doesn't mean there can't be anything new throughout the day. If there is, I will update you on social media. Go ahead and follow me at the Emily D. Baker on Twitter and Instagram, where I update that shit, or join the text crew, textemily.com. That will do too. But so far there's nothing today. And the order on the ex parte application, the application is denied without prejudice. Okay, great. Signed by the judge, August 6th. So that's a lot of infighting. Jody Montgomery has released statements. I will link those on social media. I'm not going to go over those here because we're an hour in and we have a lot more to cover. But Jody Montgomery, through her attorneys, released statements addressing James Spears' statement, saying that's not how that went down. I didn't ask for a 5150. You can't lie in a declaration. It's not that we've never seen it in the cases that we've covered where we've believed people have maybe skirted around the ends of the truth. There's a lot of ways to take a phone call, and there's a lot of ways to take a conversation. And so we will see. I mean, we've got James Spears saying, no, her team was super concerned. And now all of a sudden it's my fault. Well, I'm not the bad guy and I'm not going down without a fight. That's how his motions seem to me. I can't wait to hear how they seem to you. It seems like he is clawing to stay in power with regard to this conservatorship. All right. That was the Britney Spears conservatorship. Hello, chat. It's good to see you. I can't wait to see what you guys said about who's playing who in the Game of Thrones version of the Britney Spears conservatorship. I also wanted to give a shout out to Classy Mom. It's her birthday. So if you guys can give our mod Classy Mom some love in the chat, it is her birthday. Very, very happy birthday to you, and some good and healing wishes to our mod Katya Cotton as she is recovering. So good wishes to everyone. Let's go. What is next? I've already forgotten what we're talking about next. I think what we're talking about next is Tati Westbrook and her restraining order. And then we're going to quickly get to Jen Shah and Triller Teddy Fresh. We're going to get it done. We're going to get it done. We're going to go through the Shah stuff pretty quick. There's a lot of it, but we're just going to go through it real fast. Chat, it's good to see everybody. Thank you all for the birthday wishes. Oh, thank you for I found this randomly at a Starbucks. I think this is from their release for the fall that got leaked out early at a Starbucks I was at. It is matte black. And you know how I normally love, I love the sparklies, but there's something really fun about this one too. You know how I feel about my Starbucks cups. I'm ridiculous. All right. What did I say? Oh, I said we were doing Tati next, and then I pulled up Jen Shah documents. No, we're talking about Tati next. So much stuff has happened with Tati. Oh my God. Welcome Cindy on Facebook. First live you've ever jumped on. Welcome. All right, let's get into. I've got if you guys follow me on Instagram, I was talking about the song I was listening to before I went live today. It's still stuck in my head. So if you have seen that, you will know what's going on in my brain right now. But I don't know if this is an everybody thing, if this is an Emily thing, if this is an ADHD thing. I don't know. But it is I have the song I was listening to before I went live looping in my brain and competing for attention at the moment. Let's talk about Tati Westbrook and her business partner, Clark Swanson. By way of a very brief road so far when it comes to YouTube beauty influencer Tati Westbrook and her business partner, Clark Swanson, there's a lot of history there. There's videos on the channel. Clark Swanson sued Tati Westbrook and Halo Beauty in a derivative lawsuit, meaning on behalf of the company that he's a part of with regard to Halo Beauty in California. That case is pending a motion to dismiss or a motion to move venue into Nevada. That's going to happen next month. I can't believe it's already September. I feel like we've been talking about that coming up for 6 months because we have been. Then he sued Tati Westbrook and James Westbrook in the state of Washington for defamation. We went over all of that. It's this thick. Then the Westbrooks sued Swanson. Well, not the Westbrooks, Halo Beauty Partners. The Halo Beauty entity sued Clark Swanson in Nevada over essentially his duties as an officer of the corporation regarding not just information that he leaked to KJ without a crystal ball, but part of that. So then that pulled in the other Tati Westbrook lawsuit where Tati sued YouTube channel, drama commentary channel, T channel, without a crystal ball in the state of Washington. That ended up getting dismissed on jurisdictional grounds and then settling. It seems like from everything on social media and everything that's been released, part of the terms of that settlement agreement involved the disclosure of everything that had happened without a crystal ball and Clark Swanson. Clark Swanson denies that he fed information about the Westbrooks to Without a Crystal Ball. Without a Crystal Ball did a video saying, it was Swanson. Truth Sleuth has covered that. Drama and Opinions has really covered that. I'm sure others have, but those are the two channels that have really gotten into what was said and what KJ said about what Swanson said. So if you want to watch those breakdowns of that, those channels have those breakdowns really well. Then the complaint in Nevada came and laid those things out too. This is what these Westbrooks, through Halo Beauty, the company, are alleging that their business partner Clark Swanson did and said, including breaching confidentiality, including giving information to drama channels. Again, allegations and shade are what a lawsuit is composed of, and that's what we've got here. This is a first amended complaint filed on July 26th, because things happen when Emily goes out of town, apparently. And the first amended complaint adds an exemption from arbitration. This is still requesting business court. This is adding, let's go to the causes of action, because this again is adding a few things, but a lot of those things are also added in the request for a restraining order that we're going to get to next. So I don't want to bog us down in the entire lawsuit because we've already covered this lawsuit in the amended or the first complaint, and I'm going to the new causes of action in this amended complaint. Let's see. Swanson attempts to destroy the company. This is all of the stuff where he reached out to KJ and said things, again, allegations that he denies. KJ has a video saying that this is what he said to her. So we'll see what comes of that. The company uncovers Swanson's additional attempts at sabotage. So this is new information in the amended complaint on July 8th, 2021. And this gets to what happened after the lawsuit in Nevada was filed. The initial lawsuit was filed on July 9th, 2021. So this is getting right to that moment of filing this lawsuit, the original complaint. On July 8th, 2021, Swanson was removed as CFO by written consent of the majority members of the company. See Exhibit 1. After Swanson was removed from his position at the company on July 21st, the company gained access to his company email account. Through this access, the company gained information regarding Swanson's additional, they say, nefarious conduct that was heretofore unbeknownst to the company. We had no idea what the fuck he was up to, is what they're alleging. The company is informed and believed that in the mid-2020s, or in mid-2020, Swanson received correspondence regarding an offer of a coexistence agreement with a sports drink company in order to avoid a potential trademark opposition action. Swanson did not inform the Westbrooks of said correspondence or of the threatened litigation. Instead, Swanson failed to provide a proper duty and care to said correspondence and allowed the avoidable litigation to commence. Oof. They're alleging that there is now intellectual property issues because of inaction, thus placing certain portions of the company's intellectual property rights at risk. The company is informed and believed that in September 2020, Swanson violated the joint venture set terms regarding consensus of the Westbrooks and Swanson regarding matters related to intellectual property. That means, consensus means that this information comes to all three individuals in the joint venture, and all three of them make those decisions together, that there has to be a consensus of the parties in the joint venture, particularly with regard to intellectual property. Um, They say that by unilaterally negotiating and executing a trademark coexistence agreement on behalf of the joint venture without informing the Westbrooks or anyone else at the company, Halo Beauty Inc., and in turn, the company then lost rights to use the trademark due to Swanson's neglect of his duties and inaction. So when we get into like the tea of it all, I know there's more interesting tea, but when it comes to business duties, this becomes kind of I've realized I need a better analogy than meat and potatoes, but this becomes like the Sonic, tater tots of it all, the best part of it all. If you're bringing a business litigation, this will start, if true, again, allegations. There would be documentation of all of this because it's regarding trademark coexistence agreements. But once you prove all this, you can then show there's no question about it. The paper says what it says or doesn't say what it doesn't say. The joint venture agreement says they have to agree, and agreement wasn't had. Those things become much easier to prove because they're fairly black and white generally because it's all documented. So this becomes kind of the heart of a business action. Yes, the he said this to her is very interesting, but this becomes kind of the heart of yes, but was this company harmed by one of the members of this joint venture? And this can go to show that much more cleanly than what Swanson said or didn't say to KJ that she put on social media. By way of example, Swanson, they say, not only failed to confer with the Westbrooks regarding their wishes or seek approval for his unilateral action regarding the trademark, but he also did not take action to assure the mark's use within the legal time limitations to avoid abandonment of said mark. Instead, Swanson allowed such abandonment to occur despite the fact that he was provided a notice of allowance on November 24th, 2020, and was emailed reminders by the company's intellectual property attorney on March 17th, 2021, May 19th, 2021, and again on May 24th, 2021, the deadline. What is more, on or about June 28th, 2021, Swanson received notice of abandonment of the subject trademark from the United States Patent and Trademark Office, a fact Swanson failed to disclose to the Westbrooks or anyone else at the company. The company is informed and believed that by June 21st, unbeknownst to the Westbrooks, Swanson had been delinquent in paying legal bills to the joint venture's trademark attorney for a full year. Well, again, that will be these become the things that are just on paper and it happened or it didn't. And so again, letting intellectual property expire becomes an issue. This is put the company in jeopardy of losing various intellectual property rights. And I'm sure the attorney is one of the attached declarations here. The company is informed and believed that on or about January 22, 2020, Swanson signed a payroll proposal on behalf of the company with TPC Payroll HR Consultants, so a payroll company. Instead of providing his company-issued email, which he had since November 2017, he provided his personal Gmail account to the payroll administrator. That's interesting. In an apparent effort, they say, to hide his communications with said payroll consultant from the company. That's a look, that's just a red flag. That's just a red flag. And again, the payroll company is going to be like, here's all our emails with him, and this is the email address he used. Somebody not using or subverting or apparently subverting normal business practices is always a red flag for me. On January 30th, 2020, Swanson, as CFO, unilaterally executed an electronic service agreement with the payroll administrator. Again, probably stuff that should have gone to the whole joint venture, but or at least to the COO. The company is informed and believes that on around June 2020, using the secretive manner in which he communicated that, the Gmail account, with said payroll consultant, they say to hide said communications from the Westbrooks, Swanson, there we go. Swanson unilaterally caused two non-employees to be added to the company's payroll as full-time employees at $400 per week. What you can't do is just go ahead and add employees to the company. Collectively more than 41,000 per year. The company is informed and believes that these two individuals did not actually perform work for the company. Specifically in June 2020, Swanson allowed payroll documents adding said non-employees to be submitted by his then girlfriend, Franziska von Fischer. Oh, I hope I pronounced that right. After being initiated by Swanson from his Gmail account. 7. Okay. Footnote voice. Franziska I think that's right. Franziska von Fischer is known to be the mother of Swanson's child. However, at no time was she authorized to conduct business on behalf of the company. Likewise, Swanson and Miss von Fischer were not married at the time of this transaction. The company is informed and believes that the two non-employees are the parents of Miss von Fischer. Oh my. Edith Fischer and Heinz Dieter Fischer. Look, I just have questions. Swanson, through his other complaints and through his complaint against the Westbrooks and through his complaint in California, has said he is a very, very fancy and very, very rich businessman. He has all the companies in the world and it's just good business. And he is so smart and so wealthy and has publicly traded companies. Why fuck around with Halo? Like, why, if you want to add people as employees for whatever reason, if you've got all these other companies, why Halo? I would like to know what your thoughts are on that. Why add them to Halo? Why? This goes on to allege the company is informed and believes that there were several issues with the payroll documents that Swanson caused to be submitted on behalf of these non-employees. For instance, to date, the company has not found any reports of these individuals being hired at the company. Right. Or reports of duties performed. Right, because normally there's a process for that. Additionally, there's no record of certain records and documentation for new hires, copies of driver's licenses, passports, permanent resident green cards being provided to the company in the employee paperwork that was submitted by Miss Von Fischer for her parents. The company is informed and believes that not only were Heinz and Edith added to the company's payroll, but they were also provided with 100% employer-sponsored health insurance benefits. Whoop, there it is. Through the company. Swanson paid for said health insurance through the company's American Express credit card and did not properly report such expenses as a line item in the company's financial records. Look, you can pay health insurance on a credit card if you want to. Sometimes those miles matter, but you have to delineate it out. He's the CFO. He knows that. So they're alleging, essentially what they're alleging is that he's hiding that he hired his baby mama's, and they said not married at the time, so I don't know if that indicates married now, but the mother of his children's parents on health insurance, which in my experience with companies, health insurance can be substantially more expensive than payroll. The company is informed and believes that Swanson has paid a sizable amount of the company's bank accounts to American Express in unitemized business expenses. They say, to add insult to injury, the company is informed and believes that Swanson pocketed the company's American Express points for himself. The points fucking matter, man. I forgot that was in here. The points matter. Look, the points matter. The points matter a lot. They can look. The points matter. They just do. To date, Swanson maintains the company's financial records and American Express credit card statements at his home and has not turned them over to the company or provided the passwords to access them. So now they're locked out of their accounts. That's not good. The company is informed and believed that Swanson diverted in excess of $80,000 through wages and health insurance benefits to the non-employees without the Westbrook's knowledge or consent. I really wonder, and I don't know if we'll find out because I just don't remember. I wonder if any other employees are on medical, or if the Westbrooks are on the medical, or if the medical is just now like one or two employees and Clark Swanson's kids' grandparents. Like, that's, ugh. All right, let's keep going. After being removed from his position as CFO, Swanson communicated with payroll and gave the payroll company the go-ahead to process payroll on July 13th, 2021. So he had been terminated on the 8th, but he processed payroll on the 13th, and processing payroll would then include processing generally health insurance payments and processing payroll, it seems, by everything that's written here, for the two, as they're calling them, non-employees. So you can't process payroll, and that could include himself if he's on payroll. I don't know if he is. He could just be receiving his joint venture like quarterly payouts, but that could include paying him. Let's go on and see. Notwithstanding the fact that he no longer had authority to do so and had been expressly forbidden from handling the financial affairs of the company, once the company gained knowledge of Swanson's ultra vires conduct. The company acted to stop Swanson's attempt to divert money from the company after his removal to non-employees. To that effect, the non-employees' payroll was canceled moving forward, and the payroll was corrected so that the actual proper employees could get paid. Woof. Additionally, it has recently come to light that Swanson failed to pay the company's warehouse fees since May 2020. Look, if you're the CFO, paying the bills is one of the main duties. Like, you got to do that. Despite a chain of emails spanning approximately 9 months from the warehouse creditor to Swanson seeking payment for overdue invoices, Swanson failed to pay said creditor for over a year. Further, Swanson failed to disclose both the company's aging debts and his consistent failure to pay same each month. Each time he made a recommendation for a distribution to the members of the company, and each time he was instructed to pay all the company's debts prior to closing out the fiscal year. So, while that might not seem like a lot, that was a lot. That's a lot. Let's break that down real quick, just because that's a lot of information. So now we have allegations that he hasn't paid like the warehouse and he hasn't paid the lawyer. Those two allegations are here. Those haven't been paid for a year. But they're saying that he wasn't telling them when he was making distributions to the members. So when he's making distributions, he's saying essentially these books, well, they're alleging he's saying these books are up to date because you don't make a distribution in a company in general until the books are current, debts are paid, and then you see what profits are, and then you make a distribution generally quarterly. So if he's getting paid distributions, which he would be because he's one of the 3 individuals, they're all getting paid an equal third from the other lawsuit information that we have. He's not saying, no, there's these debts. So the debts are getting pushed. And then he's saying, no, we can go ahead and make these distributions, which is then increasing the amount essentially that he's able to pay himself because the debts haven't been paid, which is just, this is why they wanted to. I don't know how I got muted. Sorry about that, y'all. I can see why they want this to go to business court. Sorry, y'all. That was my fault. We're back. But this goes into business court pretty easily because now we know. Now we know what's going on. Well, now we know what they're alleging is going on. So hopefully we have the sound back. Hopefully. It looks like I have sound back. Sorry, y'all. Oof, this is why we want to go to business court on this case. I can see why they are alleging that. The company is damaged, they say, as a result of Swanson's actions. This is going to include the stuff from the previous one and the stuff from this one. This is a lot of information. So while the disparaging information that they're alleging here and the information to KJ and all is very interesting, what's really going to be kind of the nail in the coffin for a court or a jury in a business trial is some of these business things. Some of these business things are a lot and are paper. And when it comes to paper, it's either on the paper or it's not on the paper. You either have emails from the lawyer or you don't have emails from the lawyer. You either have, the emails from the warehouse saying we've been paid or not. The books aren't going to lie. So this gives you some of those less factual things where there's going to be factual disagreements and more solid things. Just here it is. Here's the paper. Let's get into the claims of relief and see if any were added. First claim for relief, breach of contract against Swanson and his company. Breach of implied contract of good faith and fair dealing against Swanson. That's going to add in some of the statements made, the confidentiality agreement that we've previously talked about. Third claim, implied contractual covenant of good faith against Swanson's company. Fourth claim, interference with contractual relations. That's going to be the failure to pay and losing favorable terms that we talked about in the original complaint. Fifth claim for relief, conversion. That's converting the funds and the, American Express card and those things, converting those funds to himself and causing them to be converted. Accounting against Swanson in the sixth cause of action. We need an accounting of everything. And then the prayer for relief is set forth in the statutory limits. Oh man, oh man, oh man. Woo! This stuff is, I mean, it looks like from this complaint that after they terminated Swanson and started digging into what was going on, they found quite a lot. I imagine that has been tremendously stressful. So we'll see. This is the case. Like this is the stuff that's really going to heat up because this is the the tater tots of it all, right? This is the heart of the wrongdoing, and it's going to be much easier to prove to a jury. Like, look, here's the intellectual property stuff. Look, here's the payroll stuff. That's all much easier to prove to a jury and much more cut and dry than, well, KJ says that he said this, and then in this video, she said that. That stuff is context, but this stuff becomes the much cleaner, cut and dry stuff to prove. So let's see this temporary restraining order real quick and go through some of that. It has a lot of the same allegations that are in that amended complaint because they're based on the same discovered facts. It has to make you wonder, what else are we going to see? What else are we going to see as these cases? Now it's really, KJ to the side of it all. It really is the Westbrooks and Swanson and Halo Beauty. It really is all of that mixed together. So this is Halo Beauty Partners seeking a application for a temporary restraining order and an application for temporary restraining order on shortened time. This is going to be heard on Friday. Halo Beauty Partners was forced to file a lawsuit against one of its founders, Swanson, because he is on because he is on a campaign to destroy Halo Beauty Partners' reputation, they say. Unfortunately, this court's immediate intervention is required because after properly removing him as an officer of Halo Beauty Partners requested the return of company financial books, records, accounts, and related information, and he has wholly ignored that, according to them. So that is, woo, that is, look, he's been terminated, and they're saying, hey, we need all the company records back, and they're saying that they're not getting them, and that is proper grounds for the court to intervene because the company can sustain damage. We saw a temporary restraining order granted in the Nike Satan Shoes case and in the Haley Page case, where the court is like, yes, I need to intervene right now. So that temporary restraining order can be granted very quickly. Then it becomes or can become a preliminary injunction through the course of the case. So, hey, intervene real quick. We'll make a showing. The showing is not super high, but you have to post a bond saying if you were wrong and the other party's damaged, you're going to have to pay them if they're damaged by your TRO. But then that TRO can down the road become a preliminary injunction, stopping a party from doing something during the course of litigation. I'm not surprised, based on all the information in that amended complaint, that this is what the company would seek, because they still have to run a company while all of this litigation is going on. And remember, there are 3 lawsuits with regard to these course of facts and this business relationship that are going on. I think we'll end up seeing all of them in one place at some point, but maybe not yet. They say in their request for the temporary restraining order that Swanson has continued to engage in conduct purportedly on behalf of Halo Beauty Partners by handling the company payroll. Yeah, after you get terminated and you still approve payroll, that's going to be a problem. In the course of investigating the post-removal act, Halo Beauty Partners discovered that Swanson diverted, they say, tens of thousands of dollars to 2 relatives by secretly booking them as employees for purposes of company payroll and health insurance benefits when neither of them have ever provided services to Halo Beauty Partners whatsoever. Over the last year, without knowledge or approval of the other decision makers at Halo Beauty Partners, Swanson arranged for these relatives to receive more than $44,000 in wages and approximately $25,000 in paid medical insurance. Again, in context, that's what, $80-ish thousand, under $80,000. In the other legal filings, Swanson has said, I have liquid cash. I'm very, very rich. I'm super fucking rich. In fact, this is me summarizing in my own words. I have lots of capital to fund this. I had the business relationships. I'm the one who, in fact, leased James his daily driver car because he didn't have the credit to do it. all of this, like, I'm a business genius. I'm very, very rich. I have all this money. So if you are very, very rich, $80,000 isn't that much money. So why put it on Halo and put yourself at risk in this kind of a lawsuit? That doesn't make any fucking sense to me. Like, why? Why? Is it because petty's the flavor? Is it just to fuck with the Westbrooks? Is it because you don't think you're gonna like what is the thought behind this? Because if everything alleged by Swanson about himself is true and about his other companies is true, then why do this here? He has another company that's getting paid out the distributions from Halo. He could have put people on payroll on that company if he wanted to. Whether that's fraud against health insurance is a whole different situation that we're not going to get into. But he has another company that's getting paid by this company. It just doesn't make a lot of sense as to why put yourself at risk in this way, to why this can feel like a lot of money to a company, but with everything Swanson's alleged, it just doesn't make sense that this was done. So I'll be really curious to see what the response is to this, because again, if you have that many companies and are that wealthy, why is this happening with this particular company? I would love to know your thoughts on that. They go on to say that because Swanson has acted with such malfeasance for over a year and because he continues to assert control over Halo Beauty's partners' assets and corporate records, they say apparently in an effort to further conceal his misconduct, Halo Beauty Partners has no choice but to seek injunctive relief. This application is made based on the following memorandum of points and authorities. That's going to get into the facts and the law. So let's talk about the facts real quick. We're not going to get through the law. We've gone through the law with regard to Haley Page and others. It's a preliminary showing. This is a immediate hey, you're likely to succeed on the merits of this thing. You've made enough of a showing. There is a bond up in case it harms the other person, but turning over corporate books isn't going to harm Swanson in any way. I mean, he's not still working there. So I think that it's likely that this can get granted. In satisfaction of the first requirements, the facts set forth are attached here too as Exhibit A and incorporated herein. Swanson was relieved of duties as CFO. Despite his removal, he's continued to engage in activities on behalf of Halo. He was the former CFO. He secretly added his mother-in-law and father-in-law. So it sounds like even though at the time they were added that he and his child's mom weren't married, it sounds like these are now in-laws. To the payroll and health insurance program without the knowledge or approval of the other members. The in-laws have not provided services, but they don't work here. While he was CFO, they say he failed to provide the members of Halo with financial reporting that would have revealed his embezzlement, that he was further concealing his in-laws' medical insurance coverage by paying for it via credit card, along with one of Halo Beauty's member companies, the statement for which only he had access. He attempted to gain access to the PAL merchant account, where the majority of its revenue is collected from online sales, that he refused to comply with multiple requests to return the financial books, records, related information combined with his processing payroll for Halo Beauty, including his in-laws. And that indicates his intent not to comply with the rightful demand. Yeah, they're allowed to get their books back. There is an imminent threat. Yeah, he has control of the money. Halo Beauty Partners will suffer irreparable harm by further actions in the form of obstructing Halo Beauty Partners from carrying out its lawful business without just cause or excuse, interference with the carrying on of their business, and the creation of confusion with respect to their business. They go on to say that if the court is disinclined to grant the request for TRO without notice, Halo respects and requests a hearing set and on a shortened time. And it looks like the shortened time is going to be to this Friday. They say Swanson stands to suffer no significant loss, and Halo Beauty Partners suggests that a minimal security for the requested TRO in the amount of $1,000 is appropriate. Again, the injunction bond is because if the other party is found to have been in the right, then if they are financially harmed, they get the bond. It's like, look, you're asking for this relief. It's fast relief. If they're harmed, this is the remedy for it. But again, they're really asking for the books to be turned over. There's not going to be substantial harm in that. Now, that doesn't mean that the harm of like an investigation, that's not the type of harm, because it's not harm from wrongdoing or discovering your wrongdoing. Just so we're clear, harm can come from an investigation. That's not the purpose of the TRO bond. They have a restraining order as Exhibit C, a proposed order shortening time as Exhibit D. Again, we know the date. This is the motion for preliminary injunction with the hearing requested and the points of authorities. We've already gone through the facts of this. We went through those in the complaint. And we're not going to go back through them again. If you guys want a deeper dive into this, I will do a deep dive on this document itself. A lot of this reiterates what we've already covered, but using a declaration instead. So let's go to the declaration. Sorry for all the scrolling. Sorry for the scrolling. Declaration of James Westbrook. I am the COO of Halo Beauty Partners, married to Tatiana Westbrook, successful entrepreneur, beauty industry expert, social media celebrity. Co-founders of Halo Beauty own 66%. Tati has one of the world's most popular YouTube channels with more than 1.5 billion views. She publishes editorial beauty content for a diverse audience comprised largely of women ages 18 to 45. I've known Clark Swanson since 2008, but lost touch with him around 2012 until 2015. In 2016, they were exploring opportunities to expand Tati's beauty brand. These are things that we know from the other lawsuits. Swanson told me he was a successful and adept businessman, claiming that he served as successful CEO of a publicly traded corporation. Based on this experience, Swanson said that he was capable of competently managing the business day-to-day requirements. They believed him. They formed the nutraceutical business. Take a drink every time we say nutraceutical. It's not a Tati legal filing without talking about nutraceuticals. Based on his represented expertise in nutraceuticals, we agreed that Swanson would develop the formulas. This gets into the background of the other lawsuit with he was 50%, then he was 30%. I have videos on that. That's all flushed well out in the first business partner lawsuit. We have talked about it ad nauseum, but this is going through the business's inception, changing of their structure, and breaking apart. Their initial concern with regard to what they say are Swanson's failures, their concern with him, and then getting into the move of Halo Beauty. In fall 2018, Swanson expressed a desire to relocate his family to Henderson, Nevada, and suggested that the business should be redomiciled in Nevada. To effectuate the move, Swanson proposed creation of two companies. Halo Beauty Inc. California would undergo an F reorganization into Halo Beauty Inc. Nevada, which would then serve as the intellectual property holding company. Halo Beauty Partners would then be created and given an exclusive license to the intellectual property from Halo Beauty Inc. Nevada and serve as the operating entity. Business. We've flushed this out too in the other lawsuit. In addition, Halo Beauty Inc. would hold the remaining 1% interest in Halo Beauty Partners after accounting for the 66 to Tati and the 33 to Swanson. Tati and I agreed with this plan and committed our time, energy, and resources to establishing a Nevada presence, hiring employees to grow the business. Additionally, Tati was made CEO, I was made COO, and Swanson was made treasurer, CFO, and secretary. They get into the conduct. James alleges in this declaration that Swanson's conduct worsened following the formation of Halo Beauty Partners, that despite many inquiries and repeated pleas from Tati and I, Swanson to this day never secured a corporate office space in Nevada. Swanson has not properly managed the books, they say, or timely paid vendors. Swanson did not meet development goals. Swanson made serious mistakes in developing nutraceutical products, developed a formula that contained an agreement that had been tested on animals. That came up in the other lawsuit as well. That they allege that he failed to properly manage the sales tax responsibilities. That came up in the other lawsuit as well. That he failed to timely pay vendors, even though Halo Beauty Partners had the funds to do so, resulting in losing favorable credit terms. That's in the original lawsuit in the original complaint as well. In December 2020, per Halo Beauty Partners regular practice, Swanson was instructed to pay all open invoices and purchase orders in full before they made recommendations about distributions. Swanson told Tati and me that all of Halo Beauty Partners' outstanding debts were paid and made member distribution recommendations that were approved. So that's taking the funds in the business and distributing it out to the partners because everything's been paid. Like, this is what's left over. It's time to do a distribution. In May and June 2019, a notable commentary blogger named Katie Joy Paulson began disseminating critical statements about Tati and me and about Halo Beauty on her blog at pathos.com, Through social media and her YouTube channel, Without a Crystal Ball, Paulson made several disparaging statements and assertions that were critical of Halo Beauty partners Tati and me, including but not limited to. And these are the statements that some of which are the foundation of the defamation lawsuit that we have talked about, and the original complaint in this suit. They say that Halo Beauty Partners filed lawsuit against Paulson in Washington, even though the lawsuit sought to protect Halo Beauty brand and Tati's reputation as the face of the brand. Swanson opposed the lawsuit. Swanson forced Tati and I to pay personally attorney's fees associated with the litigation, which is interesting because they went to Swanson to get approval on the lawsuit, and he said no. But Swanson, they're alleging, didn't go to them to put other people on payroll to deal with intellectual property. I mean, interesting how it's all being alleged. They then say that based on Swanson's objections, Tati and I became suspicious that he may have been involved in Paulson's statements. During settlement negotiation, Paulson confirmed that Swanson repeatedly disseminated disparaging and confidential information to Paulson about Tati and me and about Halo Beauty Partners. Again, Swanson denies that. Paulson confirmed that Swanson gave her extensive information about Halo Beauty Partners' inner workings, including who was allegedly responsible for which roles and jobs within the company, product pipelines, company finances, and falsely led her to believe that he had been the primary source of funding for the company and was losing substantial sums of money because of Tati and me. This was in violation of an agreement between the members and officers to keep information related to the inner workings confidential. They go through the July 8th majority members voted to remove him. They say, and they let him know that the removal was a direct result of failure to maintain the corporate books, deal with the accounts, take care of the K1s, collect and remit sales tax receipts. And then they go through the majority member consent, which are kind of the legal hurdles that you have to go through as a corporation when you're removing a partner based on their own corporate documents and inner workings. This talks getting to July 13th about the payroll that came up in that amended complaint. They attach the email to this with the payroll vendor, which we'll take a look at because we love what? Receipts. We love receipts. James says, when I spoke to Halo Beauty Partners payroll representative, I discovered that Halo Beauty Partners did not just have 2 employees on its payroll, the number of employees that Halo Beauty Partners currently employs. They thought they had 2 employees. But instead, they have been paying 4 individuals. The other 2 individuals on the payroll were Swanson's mother-in-law and father-in-law. Imagine being on that call. That just, ugh, and going, oh my God. Imagine being on that call. According to the payroll's company records, the Fishers were placed on payroll in June 2020, which is prior to the Fishers becoming Swanson's in-laws. This is June 2020 after he sued them in California. Hold on. I gotta go to my notes. I think that's, I don't know. I don't remember. I think he sued them in October. So this would have been, let me see. It's a lot of lawsuits. The suit was filed October 20th, 2020. So this would be a few months before he sued them, but they were going through those negotiations, and the negotiations are included in, hold on, where is it? In the mountain of paperwork. Hold on. Now I'm curious, and I've got it scanned somewhere, but let's just, in this mountain of paperwork, which is the lawsuit against the Westbrooks in Washington, it has the demand letters that went back and forth, and the demand letter sent to the Westbrooks lawyers. So they were what I'm looking to see is if they were already in like pre-litigation conversation when they were added, just because now I'm fucking curious. So August 28th, 2020 is Gibson Dunn responding to Swanson's derivative demand. Let's see when that derivative demand was sent. Because you don't wake up one day and go, I think I'm going to sue my business partners today. That takes time and effort. So the derivative demand was sent on August 3rd, 2020, as attached to the Washington lawsuit as an exhibit. And this was sent from Brown, Smith, and Kahn to the Westbrooks for the derivative demand. So August 3rd. So he puts the in-laws who aren't the in-laws yet. So he gets married in here at some point, it seems. But June, he adds them to payroll. August, he's suing his business partners. So, and they're alleging May is when he started talking to Without a Crystal Ball. So they're alleging he started talking shit, allegations, right? He started to talk shit in May to Without a Crystal Ball. He denies it, but they say, puts the in-laws on payroll in June and then makes that derivative demand in August. So just by way of a quick timeline, let's pull this back up and keep going through this declaration. So according to the payroll company's records, the in-laws were placed on payroll in June 2020 and have been collecting biweekly direct deposit checks of $800 each since that time. He says, to make matters worse, the Fishers have been receiving 100% employer-sponsored medical benefits, medical, dental, vision, since June 2020. The diverted funds in excess of $80,000. You know my feelings about that. Upon my recent examination of Halo Beauty Partners bank records, which I was able to obtain access, I also found that Swanson had on one or more occasions paid his personal credit cards directly from Halo Beauty's bank account in both May 2020 and 2021. Tati and I did not know or approve providing any pay or benefits for the Fishers. Similarly, neither Tati or I are aware of any services provided to Halo Beauty by them. In fact, I spoke with Halo Beauty Partners' two actual employees, Megan and Catherine, and they also had no knowledge of the Fishers working for Halo Beauty and signed declarations which are attached. Upon further investigation with payroll, I confirmed that Swanson's now wife provided the Fishers completed new employee forms to the payroll company in order to establish their employment. I also discovered that Swanson had enrolled his in-laws in health insurance and that Swanson had been covering 100% of their premiums, approximately $2,000 per month, with an American Express card belonging to Halo Beauty Inc. Nevada. Shortly after these discoveries, I, as COO, notified the Fishers of their termination in writing. A true and correct copy is attached. On July 20th, 2021, Swanson emailed me demanding that I reinstate. Here's the tea. Here's the tea. All of this is like business tea. Here's the like interpersonal tea, because there's a lot of business tea in this. Demanding that I reinstate him on Halo Beauty Partners' PayPal account despite his removal by the members of Halo Beauty Partners. A true and correct copy of that email exchange is attached as Exhibit 8. Guess where we're going next, folks? Guess, Law Nerds, to Exhibit 8, Law Nerds, we ride. Let's see what that email has to say. Swanson said that he was purportedly the person liable on that account and thus needed access to it. But I informed Swanson that he had already changed the liability on the PayPal account to myself. I also reiterated to Swanson to return all company property. Swanson still failed and refused to comply with that request and return all company property. I declare under penalty of perjury. 23rd day of July, 2021, James Westbrook. Exhibit 2. This is the consent of the majority members to yeet Swanson out of the company. That has been broken down above. Tati's signature looks exactly like it does on the Halo Beauty bottles, just by way of curiosity from me. Notice of termination via Gmail from Westbrook to Swanson. Mr. Swanson, now we get to be a fly on the wall. Friday, July 9th, 2021 at 5:40 p.m. Mr. Swanson, attached here to are documents confirming your removal as a director of Halo Beauty Inc. and from all your officer positions from both Halo Beauty Inc. and Halo Beauty Partners LLC. This does not impact your ownership. However, from this point forward, you are prohibited from transacting business on behalf of either entity. We are aware that the corporate Amex card is guaranteed in your name, so please discontinue use and let me know of the final balance so that the account can be paid and closed. Additionally, please make arrangements with our attorney listed below to return all company and corporate financial documents, checkbooks, credit cards, and like as soon as possible. Attorney information. Sincerely, James Westbrook. Here's all the actions that we have taken. Here is all the proper documentation to yeet you. Here is the additional written consent of the majority stockholders. The action by unanimous written consent on July 8th. Resolution, we are removing you. And James Westbrook is now the interim CFO, treasurer, and secretary. Written consent of the majority members. So this is all the corporate, like businessy business stuff behind it. Exhibit 4, Tuesday, July 13th. Hello, James Westbrook. You have been sent a secure file to download. This is from Payroll Consultants. Thanks so much for taking the time to speak to me today. Per your request, John and I were able to cancel the payroll processing for July 16th. I apologize for the miscommunication as I did not get my email before processing regularly scheduled payrolls. I called Clark Swanson this morning to get the payroll approved based on our current procedures in place. I was given the okay to move forward as usual. I gave the okay to process payroll and discovered your email after the fact. Here's a note. If you have to yeet someone from your company, take care of the financial stuff first, including calling all the people and saying this person is no longer authorized. It's not uncommon that there is something that will get forgotten, but if you have to chase money down and get it back, it's a lot harder than if you block all access immediately. You are now the only contact on the account, and an email notification will go out to you on the processing date for payroll. Please note we are processing on Tuesday for a Friday check date. I have attached the requested documentation for Edith and Heinz. This will include everything that has been paid to these employees in 2020 and 2021. John will look to see if he has any employee profiles he can forward over. And I've attached the other information for you, showing the attachments. Exhibit 5 is a declaration of Megan Carter, who's an employee of Halo. I read through this. It says, I'm the employee. There aren't that many employees. I know them. Exhibit 6 is a declaration of Catherine. Hey, I'm an employee. There aren't that many employees. I know the other employees. Heinz and Edith are not other employees. Exhibit 7, termination of purported. I like that it's purported employment. It's like, we're not acknowledging that you were employed because you were getting paid, but you weren't working for us. So this is the termination of your purported employment. I want to know what Edith and Heinz thought of all of this. I'm so curious. Dear Mr. and Mrs. Fisher, please see the attached document regarding your purported employment at Halo Beauty Partners, LLC. Sincerely, James Westbrook. Termination letter. It's not clickable, but guess what? It's right here. Halo Beauty, Heinz Fisher and Edith Fisher. Termination. As you may or may not be aware, I'm the COO of Halo Beauty Partners, and it has recently come to my attention and the CEO's attention that both of you have been on payroll of Halo Beauty since approximately June 2020 and receiving benefits. We've been unable to determine that you provided any services to Halo without conceding that you are legitimately employed by Halo or that you performed any services for the company. We want to be clear that effective immediately, you are terminated and any association you have with the company must cease. The company continues to investigate the circumstances surrounding your purported employment and receipt of benefits and reserves the right to take any necessary actions relating thereto. We anticipate that you will be provided with additional communications relating to the cessation of all benefits you have been receiving. Yeah, you're going to get information from your health insurance because that is over. If there are any facts which you believe we should be aware, please contact me by email. I mean, again, if somebody has multiple companies, why put it on this one? Exhibit 8, that's the one we were riding to Exhibit 8 immediately. Bank merchant accounts for Halo, Tuesday, July 20th. James Westbrook to Clark Swanson. Mr. Swanson, we're not like, hey, Clark. When you were removed as CFO, this is no hi, brohem. And if you haven't seen those videos, they're up where we go through some of the past communications between James and Clark that were very friendly. Not all, but most. When you were removed as CFO, you were relieved of that liability. As interim CFO, I am the new account owner of record for PayPal and now incur that liability. Please stop using and deactivate the corporate AMX card and provide me with a final invoice so that I can pay the final bill. Please comply with our request from July 9th and return all corporate checkbooks, financial records, invoices, credit card statements that you have in your possession to the address listed below. These belong to the business and need to be returned immediately. This is the email from Swanson to James. Hi, James. I see that you've changed the password to PayPal. I am on record for that account and have liability. Please have the password and my credential reinstated. Clark. It's a very short email. Like, put me back on the PayPal account. Nothing else. What? So random. Exhibit B, this is the declaration of Maximilian Fettes. He is the shareholder and counsel for Halo Beauty. So this is local counsel. The evidence attached and how it was brought about. Based on the foregoing, there's an imminent threat. So this is the attorney's declaration of personal knowledge with regard to the motion. Exhibit C is the temporary restraining order. They're asking the court to sign it. And again, if the court signs it, then the court will fill in all of this information and sign it. That could happen on Friday. We will see. Exhibit D is the order shortening time. This is going to be heard Friday, so we don't really need to go over that. Oh my goodness, it's so much information. We haven't even gotten to Jen Shah yet. Wow. We're going to find out a lot more. I'm very interested to see what Swanson has to say about this. I'm interested as to why Swanson wasn't run health. He has other companies that are suing the Westbrooks. The Clark Swanson, here, we'll just pull it up. In the California lawsuit, the first business partner lawsuit, the OG, if you will, Clark Swanson is suing on behalf of Swanson Global Enterprises, Inc. So Swanson Global Enterprises, Inc. is receiving payment because they're the partner under Halo Beauty. So they're getting the payments from Halo, those quarterly distributions. You can run payroll and you can run medical through that company. Why run it directly through Halo and run the risk? I am very, very, very curious. I'm very curious. Okay, let's get to Jen Shah because it's so much. It's so much. It's so much. I love the comments about this. The audacity to ask for new payrolls. Andrea, right? The audacity. Wow. This is Bad Lady Vet's first live. Thank you. We will definitely keep up the cursey word content. Okay. We have a lot to run through with regard to Jen Shah, and we're going to get it done. Y'all, hang tight. We're getting it. We're getting there. We're almost 2 hours in, but we're getting there. Jen Shah, Real Housewife of Salt Lake City, has been indicted by federal prosecutors. A lot has gone on. I have a whole very long, well, it's not very long. My content's always long, but I have a video breakdown of her dry contact defense, everything that she asked the court to remove. The court denied literally all of those motions. The court was like, no. We broke all of that down. After the court just recently denied that. So I'm putting a bow on the dry contact lens defense. The court denied it. There is a hearing today to set a new trial date, and we will talk about why. It's supposed to be set in October. It's not. Before we get to that, though, on July 22nd, the government in this case filed a very interesting sentencing memoranda. So if we want to get a perspective of what Jen Shah is in for on this case, before we get to what her lawyers are up to, because this all is going to play in, let's look at the government's sentencing memoranda laying out their perceived liability of the defendants. The Jen Shah case is complex. There is the Chidi case. That is the case she's a defendant in. There's also a Ketabachi case. The Ketabachi case is completed. The Chidi case is ongoing and moving towards trial. Some of the defendants have pled. The cases are all coming out of this alleged telemarketing scheme. This letter to Judge Stein says the government respectfully submits this letter in connection with the sentencing proceedings scheduled to take place on August 2nd, 2021 for Derek Larkin and Joseph DePaula. Those, it looked from the docket, had been put over, as well as the remaining defendants in the above referenced cases. Consistent with this court's order, the government sets forth its view of each defendant's relative culpability and provides the factual basis for its assessment. Relative culpability means how fucking guilty we think you are and how big a part we think you had in this scheme. Were you one of the lower tier or upper tier members of this scheme? They go on to say, as the court will recall, in March 2019, the government advised the court as it to its view of the relative culpability of the defendants when charged in the Katabachi case by designating those defendants tiers 1 through 4 and ranking them in order of greatest to least culpability. Tier 1, we think you did a lot. Tier 4, you're in this thing, but you're not the most guilt. You're not the most culpable. You're not the most responsible for the harm done to the alleged victims in this case. Bolded below and placed in the appropriate tiers relative to the Katabachi defendants are the defendants who have been charged or had guilty pleas unsealed since the government's 2019 letter, and include Carl Morris, who was charged in 17 Circ 201, the defendants charged in Chidi, the defendants later charged in Katabachi. Because many of the bolded defendants are more senior participants in the telemarketing scheme, and many continued to participate in the scheme after they became aware of the criminal charges brought in the initial Katabachi case, the government has added a new tier, Tier A, to reflect their greater culpability. You're above Tier 1. You're first class. You did the thing. We think you the most culpable, the most responsible, while preserving its prior tier designations. So what they're saying is that after the Katabachi case happened, other people saw that going down in the same scheme and went, oh, they're getting prosecuted. Yeah, cool. We're going to keep doing what we're doing. And the government saying that shows that they were well aware and continued going based on the government's theory of the case. Let's see who's at the top tier A. Oh, there we go. Jen Shah. Jen Shah. Right up in front, Tier A. They didn't even alphabetize them. They put Jen Shah right at the fucking top. Her attorneys had issue with that and said that they did that because she's a celebrity. She's a Bravo leb. Carl Morris, also Tier A, was sentenced to 78 months imprisonment. What is that? 5-6 years of imprisonment? Chat, you can let me know. Cameron Brewster, Kevin Handren, Ryan Holt, who was sentenced to 60 months, and Stuart Smith. The reason this is important is because I've been asked a lot, how much time can Jen Shah get? Well, let's look at what the other defendants have gotten. And I said this on Clubhouse yesterday. Let's look at what the other defendants have gotten, and then we get a rough sense for it. So we've got 60 months and 78 months imprisonment from defendants similarly situated to her, according to the government's theory of the case, which means this is a reasonable time frame to look at what she's going to get. What is that? 5-6 years? 7.5 years. Thank you, Katia. 6.5 years. Yeah, Jen is Tier A. Yep. So this 78 months to 60 months is what we're going to be looking at Jen Shah if she pleads. Tier 1, Katabachi, sentenced to 87 months. Christopher Wilson, sentenced to 78 months. These are defendants who have not been sentenced yet and are in the Chidi case. That's why they're highlighted. These are other people in the Katabachi case. Tier 2, sentenced to 72 months. Sentenced to 15 months. Sentenced to 366 days. Sentenced to 72 months, 366, 66, 52 months. And again, these are going to deal with their culpability, their prior records, has they ever been in custody before, all of that. So this is showing you that from Tier 2 at 72 months, with Joseph McGowan and Jack Canver, we're seeing an increase in time in this 87 and 78 months range at the Tier 1, and the government says that Tier A is more culpable than that. So I would expect that we would see Jen Shah sentenced between this kind of 87-month mark and this 60-month mark. That seems like a reasonable sentence given what they are alleging in this sentencing memo. Her defense attorneys have tried twice to get this sentencing memo removed from the record. Like, the shit's out of the horse now on this. Her attorneys are fucking pissed that she was named in this. They're pissed that this was done. Natusi asked for imprisonment versus incarceration. Yes, there is a difference between prison and jail. So the 366 days incarceration are going to be local custody versus federal prison. Federal prison being a bit more restrictive. So yes, there is an actual difference between incarceration and imprisonment. So, I didn't finish what it says about Tier A. let's finish what it says about Tier A. They say Tier A includes those defendants responsible for orchestrating the broader scheme, the telemarketing scheme or scheme, in the Western United States and supplying leads that sustained the sales floors. Leads, people, supplying the people. You know that scene in Twilight where they are leading the tourist in Italy down to the Volturi? Tier A are the ones that they're alleging are leading the people down to the Volturi, right? So they are bringing in the fresh blood. I'm sorry. I like vampire movies. Sorry, not sorry. Sorry, not sorry. And I'm not trying to make fun of the victims in this. It's just trying to give a rough estimate of the ridiculousness of the behavior here. But yes, there were people victimized by this. It's serious, you know. Tier A includes those defendants responsible for orchestrating the broader scheme in the Western United States and supplying the leads that sustain the sales floors in the New York and New Jersey area. In particular, Jen Shah and Stuart Smith obtained leads directly from lead sources and provided them to, among others, coaching sales floors operated in Utah and Nevada by Kevin Handren and Cameron Brewster. Carl Morris generated leads from his sales floors in Arizona, and Ryan Holt acted as one of the primary brokers of leads from Arizona and Utah to floors in New York and New Jersey. Shah and Smith also owned and operated sales floors in Manhattan and sold BizOp products to victims who previously purchased coaching from Harden. So that is their view of Tier A and the relative behavior and culpability of Tier A, including that they provided leads to Handren and Brewster. And Handren and Brewster have not yet been sentenced, but Morris got that 78 months. Holt was 60 months. A number of these are trying to plead. There is a court, there is a hearing now about the next date. And because the trial date is getting bumped, a number of defendants have asked to be excluded from the hearing this afternoon because they are working out their sentence. Guess who is one of them? Stuart Smith. Stuart Smith is one of them. Stuart Smith has said through his attorney, please don't make me come to the August 10th hearing at 2 p.m. Eastern time. To establish firm dates for trial because I represent to the court that Mr. Smith is working diligently towards resolution of the case. I am confident his case will be resolved without the necessity of a trial, and I hereby request that would be excused from the hearing, and the court allowed him to be excused. So this says to my prosecutor brain, Stuart Smith is working out a plea deal. I wonder how much information he is providing on Jen Shah. Jen Shah's attorneys asked for Stuart Smith's post-arrest statements. The court said, no, we don't need to give you all of those. We'll give you the relevant bits, but we're not telling you everything. And so Stuart Smith, it looks like, is working out a plea deal with the government. If Jen Shah is smart, her attorneys will be talking to her about doing the same. When given the amount of time that the other defendants has served, the number of cooperating witnesses in this case, and the fact that that a lot of the other defendants are looking to plead. And if she's left standing by herself at trial, that is a very difficult position to be in because the jury has no one else before them except for your ass. And it's hard to parse like what other people did from what one defendant did when they're talking about a scheme that the defendant, as the government's alleging, was at the top of the pyramid for. So yeah, so there's that. And as that all went on, Jen's attorneys tried to get that sentencing memo with Jen being Tier A removed from the record. The court denied it twice. And then yesterday, Jen's attorneys were like, fine, then fuck it, we're out. Fine, fuck it, we're out. Fine, fuck it, we're out. Jen's attorneys filed this on August 9th. Please take notice upon the accompanying declaration that we're going to get into of Mr. Alonzo. We respectfully move to withdraw the Buckley law firm as counsel of record for Jen Shah. Okay, well, the motions have been denied. Other defendants are pleading. Bye. We're out. Can you please remove us from the case now? Let me pull up their declarations, and I will get into some of the reasons this could happen. This could be an issue with regard to payment. This could be, hey, if she's going to plead anyway, you don't need to pay for the expensive lawyers. This could be that the lawyers are advising her of something and she just won't listen. And they're like, fine, you've got other attorneys anyway. You don't want to listen to us. Why pay us all this money to not listen to us? This could be that she might actually be considering taking a plea and need that money for restitution. That could be possible. I would be shocked. I will be very surprised if Jen pleads in this case. I mean, I think she probably should do that once they take a look at the evidence and make sure that it's all like tied to her. But it's going to be, this is a hard case. This is a hard case for her because it's so much paper. And, you know, others are pleading as well. Going to trial by yourself on this is going to be expensive and difficult. All right. The declaration says, I am a member of Buckley LLP, retained as counsel of record for Jen Shah. I submit this declaration in support of my letter motion for my firm to withdraw. On April 2nd, Shah's case was joined with the previously indicted cases. All three co-defendants are presently set for trial on October 18th. That's getting bumped. I'll pull that letter in a second. Shah recently retained Priya Chudderoy, ESQ of Chudderoy Law PLLC. Ms. Chudderoy and her partners, Beth Farber and Seth Zuckman, have entered their appearances in this matter. Shah wishes to have them represent her for all purposes rather than going forward with Buckley. Buckley is not asserting, ascertaining, or retaining or charging lien on its case files and will assist in transitioning the matter. There's no money outstanding. We're just turning it over. It's fine. There's no lien on this. We're just turning it over. New counsel is aware of and able and willing to meet all existing scheduled court dates and deadlines in this matter, including the pretrial conference dated October 8th, which again was moved to today, and any new ones agreed upon by the parties and imposed by this court. I've been in contact with counsel for relevant parties. Counsel and the government have no objection. The court granted this yesterday before the motion today. And let's just pull up the court's notice with regard to trial, because the court gave notice that trial was going to have to bump, and that notice was given, why don't I see it in my notes? I don't see it in my notes. Darn it, because I didn't put it in there. Let me pull it up in my G drive. Either way, yesterday, the day before, the court said that due to a lack of courtrooms, the trial was going to have to move. The court filed it for all parties and then set a date for today to look at picking new dates. So let me just pull that up so you guys can see it. And then we're going to have to very quickly go through our last bit because we've been on for over 2 hours. Not shocking. Where is the court's ruling? Not this one. I link most of my documents in my prep for each show, and somehow this one just didn't get into it, and I don't know why. That's the order to withdraw. Don't see it. Maybe I didn't pull it. Did I download it and not put it in here? Either way, I'll put that up on social if you guys want to see it. But due to lack of courtrooms, et cetera, the trial is getting bumped. I was more interested with the court's ruling with regard to denying Jen Shah's motions. Again, the court did not find the dry contact defense to be illuminating or helpful, and found that she really robustly waived her Miranda rights to speak with police. So the trial's not going to happen in October. We should get a new date this afternoon. We will see if that gives everyone time to plead. There are quite a lot of plea deals in the works, given the court docket of all of the different defendants who have asked to not be present at the trial setting. The only reason you don't want to be present at the trial setting is because you don't intend to go to trial because you're in the middle of working out a plea deal with the government. Again, that would be very, very bad for Jen Shah to be the last man standing, or the last man, woman, the last person, the last individual standing at trial, because the jury has no one to look at but her. And you can't use the defense strategy of going, yeah, but they did this. They're worse than her. She would be the only one sitting there. And that's a very, very difficult thing. Valerie asked, lack of courtrooms is an excuse. Yes, lack of courtrooms is an excuse in the middle of a pandemic. That might not always fly the same way, but right now, that is definitely an issue, especially with new health orders that are existing in New York. So that is what it is. Here, let me just pull it up real quick. We'll just go back to Pacer directly and pull it up. And then we're going to talk real quickly. I'll do a deeper dive on Friday um, about Triller. So let's pull up Jen Shah real quick. Oh, let's see. We're going to go through. Do you guys want to see the docket? Sure. Let's take a look all together now. Oh, there's a new memo endorsement. Excusing the appearance of, this is another defendant who's playing Shane Hannah. So we've got a number that are playing and have pled, and the court was like, yeah, you don't have to come. Let's see where the note from the court is. This is the sentencing that was moved. Order, no courtroom. Here we go. Let's just view it again. All right. Judge Stein. This was from 8/3. So what was that? I don't even know. Last week, end of last week. I was not back from vacation yet. The court has been informed that as of today, no courtroom can accommodate the trial for 3 defendants under COVID compliant conditions. Accordingly, it's hereby ordered that there will be a pretrial conference in courtroom 23A on August 10th. Remember, this is an 11 defendant case. So right now we're looking at only 3 that are ready to go to trial, Jen Shah being one of them. So August 10th, 2 p.m. to establish firm dates or dates for trial for the defendants who have not already pled guilty in this action, consistent with the requirements of the ad hoc committee on the resumption of jury trials. That means defendants who have not already pled, that 3, it seems to me, would include Stuart Smith. So it'll be very interesting to see what the court does with that. We're going to make sure we've got it saved just for future reference. All right, last thing that we're getting to. We have so much to get to today. We're going to talk about Triller real quick. We're not going to have a ton of time to do questions today. I'm going to swoop through and say hello, but I will be leaving more time for questions on Friday. So just know we will be back live, and I will be live with I will be posting our members live stream for the month to the members later today, tomorrow. I will be live with vidIQ talking about like lawyery creatory stuff. And let's get to Triller real quick. Yes, I will go over the super chats before as best as I can after we get to Triller. So let us pull up Triller real quick. They filed a second amended complaint. The Triller case with regard to Film Daily looks like it's on its way of getting kicked out for lack of prosecution. The court's not thrilled. I should have swooped. Let's swoop. Triller versus H3 et al. The Triller case started in a flurry of everyone being improperly joined. All of the defendants they added got kicked except for Film Daily. I'm watching that case too, and it looks like the court is not thrilled with the lack of prosecution. And Triller's like, we couldn't find where to serve them. You have a set amount of time, 60, 90 days, depending on the court, to serve somebody. If you haven't served them, the case can be yeeted for failure to prosecute. You have to tell someone they've been sued. You can't just sue them and then do nothing about it. You have to serve them. It looks like there has been service in this Triller case. It doesn't make the case written any better. Triller Fight Club has filed a second amended complaint. What's so interesting about this, just the shade of it all. When Triller initially sued, they sued under the wrong company name. So it wasn't Triller Fight Club 2 LLC that initially sued. Like, they had to file a first amended complaint at the beginning of this because they sued under the wrong plaintiff company name. That's what this suit has been like since the beginning. Mess of mess. So this is now Triller Fight Club versus TED Entertainment Inc., Teddy Fresh Inc., Ethan Klein, and Gila Klein. So all the things. This was filed on July 23rd, right before I left for vacation. And this is the notice of the action. Again, over the Jake Paul Ben Askren fight, we've been over it. People streamed it, blah, blah, blah. With regard to Ethan and Gila, though, There was commentary on it. I don't remember Gila being present on the H3 podcast where they talked about it. They've linked the video. I think did they link it with a timestamp? No. We went through it. It ended up being moments of this, 2-hour long podcast. It was moments of Ethan talking about this fight. I'm scrolling down here at the bottom. This is the fight. He starts talking about it at like an hour and 26, 27 minutes in, and then is kind of done at like an hour and 32 minutes in talking about this fight. Gila, by the way, Gila not present in that conversation, but okay. Let's see how they're trying to rope in additional defendants, because we've broken down this case. They're saying that the distribution video has been viewed at least 1 million times. Yes, it does have over 1 million views, but it only shows a clip of the fight. I still think it's fair use because it's commentary after the fight was done. You can watch my other video. I yell about that a lot. This whole lawsuit. I normally will be like, look, you have a right to sue, blah, blah, blah. This one's fucking stupid. It's fair use. It's commentary. It's well after the fight. And it makes none of the sense. It makes none of the sense to me that this is the way that it's going. This was so poorly written at the beginning. This whole suit just is a disaster. So let's see how they think that they're going to bring in the other parties. Plaintiff is an LLC incorporated in Delaware, working in California. Plaintiff is engaged in distributing copyrighted materials. Plaintiff owns the copyrights of the broadcast. Fine. TEI is a corporation registered to conduct business in the state of California. Upon information and belief, TEI owns it. Well, if you're calling it TEI, why isn't that what it's called up here? TED Entertainment Inc. Okay. When you're listing the parties, it just makes sense to refresh this statement, but whatever. Corporate parties. TEI owns and operates, among other things, the so-called H3 podcast. It's a podcast. It's like saying lawyer, the lawyer. It's like, no, it's a statement of fact. I either am a lawyer or I am not, and I am by education, trade, and bar passage. But the so-called H3 podcast, that's the name of the fucking podcast. I mean, they're trying to be shady, but they're not good at it. The H3 podcast, and the YouTube channel located at, and this is their channel. Upon information and belief, TEI through the H3 podcast and YouTube channel earns profits, including from YouTube partner programs, sponsors, from unaffiliated third-party individuals and entities, the sale of merchandise through businesses affiliated with defendants. This is the part where they're trying to rope in Teddy Fresh, including but not limited to Teddy Fresh. Teddy Fresh is a corporation registered to conduct business in the state of California. Teddy Fresh is a clothing retailer. The YouTube channel and or videos posted to YouTube channel contain links to a website owned or operated by Teddy Fresh. So you want to sue Teddy Fresh, the company, for copyright infringement because there's links to their company and videos? What? What? Okay. It contains links to a website owned or operated by Teddy Fresh, right? Teddy Fresh is a separate fucking company, from my understanding, and through which customers can purchase Teddy Fresh merchandise, right? Teddy Fresh merchandise is separate because it's separate. Mr. Klein is an individual residing in the state of California. Klein is CEO of TEI and secretary of Teddy Fresh. Oh, okay. Klein is an individual residing in California. Mrs. Klein is secretary of TEI and CEO and CFO and sole director of Teddy Fresh. Right. It's Gila's company. And it's Gila's company. Promoting a company on your YouTube channel does not mean you become like liable for them or they become liable for you. Like, that's not how that works. And that's why they're getting into these alter ego allegations, trying to show that Teddy Fresh somehow is responsible for Ethan on his YouTube channel giving commentary about a fight. It's My arms aren't long enough to reach that far. Upon information and belief at all relevant times, there existed a unity of interest between defendants such that any individual or separateness between them has ceased. For these purposes, this has nothing to do with Teddy Fresh. They're trying to say that Teddy Fresh they're inexplicable. They are alter egos of one another. It's like saying, Erica Jane and Erica Jane Entertainment Company are alter egos of each other. Erica's operating through her hire out company. Those are proper alter egos. The individual has a hire out company. That's the company that does business. But the whole business of the company is the entertainment of the person. Proper alter egos. This is a clothing company and a YouTube channel. Yes, it provides, it's not even really H3 merch. Teddy Fresh is its own uniquely designed stuff. Yes, the clients wear it. Yes, it's Hila's company, but if the YouTube channel didn't exist, if the H3 podcast didn't exist, Teddy Fresh would still be a going concern and entity. They're not inextricably linked. It's even different than the way Halo and Tati are linked. In this case, because Ethan is really kind of the head of H3. Okay, we're going to keep going. We know how I feel. TEI and Teddy Fresh are, and at all relevant times, were mere shells, instrumentalities, and conduits through which Mr. Klein and Miss Klein carried on the business in the name of TEI and Teddy Fresh, while exercising complete control and dominance over TEI and Teddy Fresh, their businesses and assets, to such an extent that any individuality or separateness between TEI and Teddy Fresh on the one hand and Mr. Klein and Mrs. Klein on the other did not exist. TEI and Teddy Fresh share inter alia corporate officers directed as well as corporate offices. I think it's going to be easy to argue TEI is the company for the YouTube channel, TEI and Mr. Klein. But when it comes to Hila and Teddy Fresh, I don't see how they're going to get there without more than like Ethan wears Teddy Fresh and there's a link. Okay. TEI and Teddy Fresh were conceived, intended, and used by Mr. Klein and Miss Klein as a device to avoid liability for the purpose of substantiating and undercapitalizing an entity, namely TEI and Teddy Fresh. I don't know how they would know Teddy Fresh is undercapitalized. This is all them trying to pierce the corporate veil. So they're trying, it seems to me, this is my opinion, that Teddy Fresh is probably the entity that makes the most money, or they're perceiving that Teddy Fresh is the entity that makes the most money. And they're trying to find some way to loop Teddy Fresh in here because TEI is the operating entity of the podcast. So if that's true, TEI would be who runs payroll for the employees. And a lot of the times those are just on rolling capital. There doesn't need to be substantial capital sitting there for it to be properly capitalized, but they're trying to pierce the corporate veil to go after Ethan's assets, Hila's assets, and Teddy Fresh's assets, which on a copyright claim is I don't know what that noise was, is a very interesting choice that I don't think is going to fly. They say TEI and Teddy. We talked about that. Mr. and Mrs. Klein diverted assets from TEI and Teddy Fresh to themselves to suit their own convenience in carrying out business matters. And they should have been the domain of TEI and Teddy Fresh. These are interesting allegations because I don't think they've done discovery yet. And these are all just, they're not even saying on information and belief. They're asserting this as fact in this complaint. And I don't know how they have those facts. They say TEI and Teddy Fresh are at all times here mentioned, controlled, dominated, and operated by Mr. and Mrs. Klein as their alter ego. Yeah, but Hila has nothing to do with any of this and wasn't even present when the alleged copyright infringement happened. They say that they were carried out without annual meetings, without keeping records or minutes of proceedings, and without maintaining written resolutions. Again, I don't know how they would know that. It doesn't say on information and belief. They're trying to hit the bullet points of piercing the corporate veil without actual facts and just blind assertions, which means at some point just a motion to dismiss is going. It's going to be like, you didn't prove anything. You just said a lot of stuff. So this is going to be expensive and annoying for Teddy Fresh. Now has to deal with it because they are it seems that they are a separate entity. Gila's going to have to deal with it because Teddy Fresh seems to be, this is my perception from watching their channel, seems to be the owner, operator, designer of the clothing line. It's not even really merch at this point. Like Coffee and Cursey Words over on lawnerdshop.com is merch. What Phil DeFranco puts out is merch. It's related to him and his channels and things he says. But Teddy Fresh is a clothing line. Yes, it's related to the Kleins, but it is not H3 merch. It's not Frenemies merch. Yes, Teddy Fresh designed the Frenemies merch, but even that doesn't tie you into here. It's a separate company. And even then, I imagine that the H3 Productions or their company hired Teddy Fresh to do that, and that there was an agreement as such. Count 1, copyright infringement. Count 2, vicarious copyright. Vicarious copyright infringement. Lord. Count 3, violation of the Federal Communications Act 47, 605, because they're not the publisher of the broadcast. And then prayer for relief, the 150 per violation. You know, they're asking for all the money, which they have done. It looks like they're just trying to slap it where money might be in this. I don't think they're going to pierce the corporate veil. I will do another more lawyer law episode with regard to piercing the corporate veil, because it is deep businessy stuff with trying to establish these alter egos. I don't think this is it at all. But it's like if in the Erica Jane and Girardi case, if they say that Erica's company, EJ Global, was loaned $20 million and EJ Global is just operating as a hire out company. They go ahead and they take in the money from Bravo. They make the agreements. They're the kind of protecting entity that hires Erica Jane. There might be some reason to go in there and say, okay, well, the money was loaned to EJ Global, but that money really just passed through directly to Erica Jane. And so maybe trying to pierce the corporate veil, they're saying this is a sole proprietor. All the money went directly to her, what have you. You have a closer nexus there than trying to say a clothing company, Teddy Fresh, that happens to be owned by the wife of the YouTuber who is the one that talked about the fight. It's much more tangential to me. And I just don't see it. I just don't see it flying. Okay. I'm trying to get to super chats and I have questions just real quick, because then I not only have questions, but I have to get rolling because I have other stuff to record today, including a podcast for y'all. So questions, I'm trying to get to super chats, and the back end of my channel is just not playing nicely with me. But chat, this was so much. It was so much stuff. All right, let's see. Yeah, the back end of my channel is not letting me pull up anything. That's weird. All right, let me try one more time. I'm going to do my best. The vicarious copyright infringement is actually such a very interesting thing, isn't it? Talking Shitsu, we will definitely get into some of those charges. I wanted to kind of give the overview of what they're saying and what they're dealing with the piercing the corporate veil. Talking Shih Tzu said, I had a judge deny piercing the corporate veil where a sole proprietor literally used the bank card for the LLC as his own personal bank account. It is tough. It's very difficult. This is just not going to go well. Question, what happened with the cease and desist letter from Clark Swanson? I replied to the attorney and I have not seen that they have replied back. I privated one of the videos because they asked and I felt that was okay to do. And I did it as a courtesy and replied what I would be privating and what I would not be privating. And the video I privated, the information in that video is all contained in this. So if I cover it again, it was all provided in this new lawsuit and we'll just cover it from here. So that's what happened. Yeah, this will not let me pull up my super chats on the back end. Apologies. Thank you for the support. I'm going to go to the ones that I can see and extra special thank yous if I can't see it. So basically Ryan Kavanaugh, big mad and has a lot of money for litigation to be annoying. It seems perhaps that way, and I don't know why. There are other litigations that we've talked about involving Ryan Kavanaugh. I'm gonna have to remember which one. It might be the Terrence Howard one. I think he was a producer of that movie that Terrence Howard is suing over. I'm gonna have to look it up. $5 super chat. So was Paula Proctor on Crazy Ex-Girl. Oh, I can't. It won't let me pull up any of these, you guys. I am so sorry. The whole back end of my channel won't let me pull up any of those super chats. Lucy said, "Are you going to get into the whole meme BS? Because this is wild." I don't know what meme BS you are referring to, Lucy. Please let me know, and maybe on Friday, because we're not going to do much of it all. Deb said Ron Richards tweeted that the Shah trial set for March 2022. That doesn't surprise me at all. Question, will I be covering Todd Chrisley and Without a Crystal Ball when there is a filing? I will. I talked about it a little bit more on Instagram yesterday. If you saw my Instagram story from yesterday. Yeah, I can't pull up any of the super chats in the back. Sorry, I cannot. I appreciate the super chats. I see some of them. Athena said, I missed you. Hope you had a great time away. It was a good family trip. Ashley Vincent, catnip tip. Thank you. Yeah, I just cannot. Weird. So y'all, I'm sorry for the super chats. I will try to pull these up a little bit. Thank you. I appreciate it. I just cannot. Yeah, it's the back end of the channel is just being super weird, which is probably a YouTube thing at the moment. And I don't think I can get back up to all of them. Let me try real quick to get to some of them. Because I have infinite scroll from StreamYard. So let's try to get to a few. So was Paula Proctor on Crazy Ex-Girlfriend based on you, or do you just embody the best character on the best TV show? I've never seen Crazy Ex-Girlfriend. I'm sorry. I have not, but probably not. But I will have to look. Let's see if I can get to a few more of these, because you guys, I'm loving Infinite Scroll. Yay to StreamYard. But I just can't believe I can't pull up the back end. That's really, really weird. I'll have to figure that out after stream. And to all the members, I am filming a video for you guys afterwards. If you want to become members, hold on. There's a new level coming out. For everyone who just joined, thank you. You will be getting that video too. We are doing some changes to the membership, so everybody who's in it will get all that information. But we've got some big changes coming up and some good changes for some more exclusive content. Athena Evans, I miss you. Hope you had a great time away. Thank you. Yeah, let's see if this will let me get back up any further. I always try to acknowledge the help supporting the channel over here on YouTube. Thank you. But today it's making me work for it. Abby says, I heart Rosengart. He puts effort, unlike Ingham. It feels that way. I'm over here fist pumping for the eloquent FU. He is so beautifully executing the sass. It is sass, and he definitely painted Dad Spears back into a corner, didn't he? And it'll be interesting to see what the court does with that. Joe Jersey, thank you for all the good vibes. My son won primary custody of his daughters. Congratulations, Joe. That is a very difficult thing to go through. Family law is really tough. I don't cover a lot of family law on this case because it is tough. Andrea said judicial protectionism, bench before Britney. Fair enough. Let's get back and see if we can get to any others. Again, thank you guys. I know it's been a long time since I've been live. Sandy said it's very sad that Britney is paying all the costs for her own abuse. I mean, all of the cost. Fathers are supposed to protect you. So sad she got a lemon in that regard. I love referring to James Spears as a lemon. That's hilarious. It's not hilarious for Britney. It is really tough to watch her paying for all the legal fees. Though I will say Rosengart has pointed out that if these motions and the objections that Spears is lodging based on these motions is not in the estate's best interest, he is going to ask that James Spears pay his own legal fees for those. Joe Jersey says, I get bad vibes from Dad Spears and Ingham's are connected somehow. Maybe just me though. Well, Ingham's out, but he didn't object for like 12 years. So there's a lot of questions there. He also was getting paid, you know. Lizzie says it's obvious whose side the judge is on. She does not believe Britney or her medical team. She is corrupt. Dad Spears will never be removed, it seems. I mean, at this point, he has to be. They're not going to stop fighting for him to be. And I imagine as we go forward, Rosengart is going to be less and less patient with the judge. I've definitely been in that position. You've got to start patient, but you don't always have to stay patient. And hopefully, if that starts to turn, we will see that in the language used in the motions. We will start to see if Rosengart starts to get snappier with the court. Lilycat said, according to CNN, Andrew Cuomo has announced that he is stepping aside from office. Just FYI to everyone, since someone brought it up. Thank you. Starbucks Fund. Thank you, Danny. Appreciate it. And this is the one that we had gotten to at the beginning, the lead attorney. Let's hear about Britney. We absolutely covered it all. We mentioned it all. We're at over 3,000. There have been over 4,000 of you this whole stream. Thank you so much for your support. If you are new here and have not hit the subscribe, hit the subscribe. Triller is trying to sue Ethan over memes on his subreddit for defamation or something. I'll pull it up. That would be silly, but I'll pull it up. I mean, wouldn't that just be in federal court as well? Hold on. Now I'm curious. And the mods are like, no, don't get curious at 2 hours and 30 minutes in. No curiosity allowed. No curiosity allowed. None at all. Let's, I will do a party search for that. I'm going to make a note and I will pull it up for Friday. So Lucy, that will come up on Friday. I have been catching up on all of this because I've been gone. Love the lavender color. Thank you. It's definitely my faded purple, but I want to see how it fades. So we're just going to see what happens. Question, is your podcast just the audio of your YouTube videos or is it a completely different thing? Some episodes are completely different. I will always make it clear which is which. But most of the episodes are also uploaded here as the Emily Show episodes. There are a lot of older episodes that are not on the YouTube channel. It's been, the podcast is over 1.5 years old. So there's a lot of back content that never made it to YouTube before I started doing video versions. Some video versions are here on the channel as well as video uploads. Those always say the episode number at the end, so you know that it's an Emily Show and it's got that different intro. Some are not. So tomorrow's episode's not on YouTube at all. It's an interview I did that's really fun. A lot of episodes go up both audio and video, and there's a video playlist here. But the older stuff, the back catalog's not here on YouTube. So yes, I generally record those Emily Show episodes to go both audio and video so people can choose. Question, not a question. But Ethan went over the complaint on After Dark. I will go check out what he had to say. I mean, I don't know if Ethan and Gila, as business owners, going through piercing the corporate veil and, corporate personhood and all of the deep business association stuff. I can imagine looking at that. You would be like, what in the fuck are they trying to say? But they're trying to say that somehow Teddy Fresh is responsible for what Ethan talked about on his YouTube channel. And it's a lot of a stretch, in my opinion. And it's not going to fly. But the problem is, even if it doesn't fly, it can be very expensive for Teddy Fresh now has to have counsel, or have the same counsel and make sure that they've done the proper waivers, because they are separate entities. And it's just so much. So it can be expensive and annoying for them. And that's really hard. So yep. Brenda Lynn said, dang, I have to hit the replay in a bit, but this is the first live. I got 0 notifications on any social. Brenda Lee, I tweeted it. I Instagrammed it. I text crewed it. So if you didn't get them, I am sorry. Those are the places where I send them. If you're in North America, the text crew at textemily.com, you will get a text about a half hour before for sure. I've been missing your lives. How was vacation? I talked about it a little on Instagram yesterday. I've got to wrap up here because it has been long. I've got to go, but we will. They cited Reddit post and tried to blame Ethan for it. You can't sue someone for defamation over shit they didn't say. That's just, you can't. Yeah. You just can't do that. You just can't do that. Oh, Angel. Yes. Good point. We could definitely have more likes. I have not asked at all. For likes or subscribes. So make sure you go ahead and like and subscribe. I did not say it at all. I did not say it at all. So I will be back on Friday. Tomorrow, I will be on vidIQ's channel talking YouTubey things. And that is where I will be. It will be a busy week this week and next week. I appreciate all of you for being here. Thank you to the mods for an extra long ride. I knew it was going to be long. I didn't anticipate it being quite that long. So I apologize and I appreciate you. You guys, lots of love to the mods for hanging in for this very long show. I will get to more questions on Friday as we will have less items on the docket. But those are the top 4 things I wanted to cover. And I feel like we smashed it. Thanks for being a Law Nerd. Thanks for being here. I will see you on the socials. Don't forget to follow there because that's generally where I get information out more quickly. And a lot's happened while we were live today. So we're just going to go catch up with it and share it on social. So with that, it is time to go. Thank you. I'll see you soon. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, LawNerdsUnite.com. Happy to have you. Support what we do here on the YouTube